Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right to with the facts, pretty brown girl with the sass. Marildia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial, trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you write a line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial, trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made of gold. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas kneeling strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Good morning and happy Sunday. Happy Sunday fun day. Hopefully that's what you got going on. There's nothing like having fun on a Sunday. Oh man, oh man, oh man. I tell you, this road to justice is going to be like, it almost reminds like in Florida with the Adelsons, like, wow, oh we. Oh my goodness. Like, can't we all just get along? No, of course we cannot all just get along. It always got to be something. Oh, I'm telling you, these crimes is criming. These people is doing these crimes, baby, and don't want to do this time. Okay, so good morning, all. I'm glad to see you here. First, let me start off by saying I am going to, so we are officially in part 3 of this, and I think that I may keep it going like, not, I know we going into the trial, but you know, her trial is afterwards, and what I decided to do instead of putting most of her pre-trial stuff in here, I decided to wait and I'll do some of her pre-trial stuff when it's time. When it's almost getting closer to time for her thing. But let's start off here in regards to our Microsoft executive, Jared Bridegan. You know, trial is supposed to start tomorrow. They are supposed to have jury selection. They're bringing in 100 jurors. I guess they can, I think that his jury may be easier to pick through versus to Shanna's jury, because, you know, they were picking her jury the 31st, I believe. So I think that a lot of people may be exposed to the case, especially by being like televised. Like it's gonna be on all the major networks for at least a week or so. So yesterday we followed the investigation. We watched how investigators say this case went from looking at Tenon as just like an ambush thing and actually finding information to put him in connection with Mario. And the way he got connected to Mario is because of once they tracked the plate number from the surveillance video, it tracked, to Henry, and then they went to Henry's house, and then like, what the hell? Like, okay, you don't have any relation to Jared. No personal, no business, no, I know a friend of a friend of a friend. So who do you know? Then they find out, he is renting from Mario. Who is Mario? Mario is Shanna's estranged husband. The trainer. We like them trainers. I'm telling you, men, don't be letting your wife go be trained by no man. You could do it if you want to. You better be her trainer. Because if not, you might lose her. Yeah. And that's how he lost. And she got out here in these streets. So that's how that's what we did yesterday. We kind of like followed the evidence. We looked at the money, right? We seen the money that Henry received. He received a total of $10,000. Henry don't look like he doing anything out here as far as work or doing anything to earn $10,000 at the time that he received it within a month's time. Okay, let's get that straight. Not to judge a book by its cover, but yeah, what was he out here doing? What did he file taxes with that for? So of course they followed the money, and we also seen the communications of where him and Mario's communication started picking up. We also saw where, he drove by the scene pre-redrum, and we watched his arrest, right? We didn't watch his interrogation video. As I stated, it's like 6 hours long. Half of it is in there with him, at least the parts that I did see, because I am recording it so I can publish it. But the parts that I did see, he does talk, but like for the first like hour or something, it's like they have elevator music playing and he in there twiddling his fingers and thumbs. I almost need to go past that part, but you never know if they do something while people are outside of the room, but it has so much music in the background. I'm like, what is he doing? Like, it make you feel real comfortable in their interrogation rooms. Like, I'm like, they got the little music going. Like, I thought he might have started singing or I don't know. But so I do have an interrogation video. I will get it up at some point in time, or it may be stuff that we can watch during the downtime as we enter into trial. And we also looked at where Henry decided to, hey, no, I don't want them 15 years that y'all giving me for this horrible crime. I don't want those 15 years to life for this horrible crime and testify against the people that actually allegedly put me up to doing it, Mario and Shanna. Instead, I want to take this shit to trial. I was like, oh gosh, no, he doesn't even sound like he knows what he's doing. If you missed it, please go back and look at it. We watched him take his plea, and he still looked like he was confused. He said he didn't understand when he accepted the plea, and even when he was withdrawing his plea, he didn't look like he knew what he was doing. And it reminded me of when we seen this, that case that we watched with the beheading with Devin McMichaels, the one that was, maybe it does have some relationship to the Monica Simatilli, because remember, her boy had some, Monica Simatilli's boo thing had some relation to Devin McMichaels, but they tried to give her a plea deal, and she got in there acting all cuckoo for Cocoa Puffs, and the judge was like, sure, I'm gonna withdraw it. The state was like, sure, we fine, take this to trial. Now she behind bars for life. She should have took that plea deal, and I think Harry is gonna think the same way once it's all said and done. He should have took the plea deal and tried to figure it out. That's what he should have did. But today we're going to be moving out of the investigation and we're going to go more into the courtroom, because this case, the case that investigators built that the jury is ultimately is allowed to hear, are going to be two different things. I know yesterday I heard we had some things in regards to possibly the 2-year-old who was in the car at the time of the incident. So I do have the motions in regards to that. We'll watch we'll watch some of the pretrial hearings, and break those down. And the one hearing that I was not able to find any information on the one hearing, but I was able to get the motions, and we'll go over the motions and what the judge decided. And that's in regards to our girl Kim, Miss Talk Too Much, sitting in the interrogation room, just her. In regards to her motion, I see where we'll go over the plea emotions where Mario like, hey, we were married at the time. I'm using my spousal privilege. I was like, oh, okay. So now we get to see where he is able to invoke this. Although their trials are separate, guys. Yeah, he invoking some of this spousal privilege. So we'll go over all of that stuff today as we go through. And as always, our judge, London Kite, that's going to be presiding over all of these cases. She had to make some pretty big decisions in regards to this. So today we're going to find out why the trials were separated, what changes, what charges Mario is actually facing, because some charges were actually dropped. So we'll go over that portion. And whatever major evidence that the state may have wanted in that was not allowed in, and just some of the fights that I think that the defense actually won. So we'll see exactly, and we'll kind of go from there. But let me go ahead and we'll say our good mornings, good early afternoons, evenings, and then we'll get into our content for today. Hey, Christine. Christine said, I'm at work. Awesome. Hope you're having a good day at work, Christine. Hey, SD, good morning. Hey, Film, good morning. Or, no, it's afternoon. Early afternoon. Hey, Jason. Good afternoon. It's early afternoon. Hey, Gabber. Good afternoon. Martina, good early evening. Hey, Analyze Doug. Good morning. Hey, Merelda. It should be early evening early evening. I ain't going to say it's nighttime. I ain't going to put you to bed just yet. I'm not going to do that to you. So, thank you so much, SD. Yes, I think that this will all be interesting to see as we go along in this case. Y'all know, and we'll touch base in regards to our plans for the week over here. I did put out a poll in regards to us if we should cover the Tupac murder trial with Keefe D, right? Oh, man. So I got to get and see. I got to go and see with the poll, but it looked like I think a lot of people want to see it, y'all. It's a later trial because it is happening in Vegas. So they are on the West Coast, best coast. So I know that we are in our Lindsay. Why I call her Lindsay? Oh man. We are in our Lindsay Clancy trial at the same time. I will say that I am like I don't know. We got to figure it out because this trial right here is in Florida. So it is on the East Coast time. It's on the same time zone as Lindsay's case. Let's get that straight. And then we also have our OnlyFans model, her plea deal tomorrow. I don't know how long that's going to be. And I know a lot of people are interested in seeing that, right? So I don't know. I really don't know. Like, we in a conundrum because we got a whole bunch of stuff because everybody out here crying, and for some reason they decide to do all this stuff on the same day, or start the trials or do plea deals or whatever. Yeah, so I guess I'm gonna think about it. I already put the Clancy uh I put that out there already for us to be able to see. I figure I don't know if the jury will be seated for Tupac because that's tomorrow, right? So I don't know if his jury will be seated tomorrow. Maybe tomorrow afternoon. This jury for Mario, maybe tomorrow afternoon they'll start opening statements. We'll keep our eye out for it. And then I know everybody wants to see the cross examination of Lindsay's doctor, Jennifer Tubbs. I know I'm looking forward to seeing it. Let's see what Reddington, if he, what he can get out of her in order to assist Lindsay in her case. So I guess we just got a whole bunch of stuff, guys. It's a whole bunch of stuff. So I don't know. I don't know which way. I'm like, I don't know which way. I mean, we'll be on stream all day and all night. And we don't want to do that, right? I'm not trying to do that. I can't do that. They won't let it happen. So we'll see how we do. So we'll see how we do. I'll see what everybody kind of wants to. I don't know. I don't know how to make. Of course, I want to make everybody happy. I want to kind of. But y'all know I will give up on a. Y'all know I will give up on a trial real quick. And just do updates. Sorry. Sorry. And Lindsay may be one of those cases. Cause I'm like, besides, I guess because it kind of like puts us all in a little bit of emotional turmoil. At least for me. At least for me. Cause I'm like, at least for me with that case, like I just like it's like one of them cases. I'm like, let the professionals handle that. Just let them handle that because I'm not, I don't understand none of this. I understand it to a point, but I understand it from coming from a person that doesn't have a mental health background. And I mean, I guess they all know, they know it. I find it, they know everything, I guess. I don't know. They know more than what I know, but I'm like, I be looking at some of these comments in regards to this lady and I'm like, I don't know. I don't know. It's like everybody go hard in the paint for what they want to go hard in the paint for, and that's what I don't understand about this. And so sometimes I get in my feelings about it. So that's why I was like, I don't know. Like we gonna go hard in the paint. I want everybody to go hard in the paint about the other people. They don't go hard in the paint about all the other people. So I'm like, I'm cool. Yeah, I think they got off to a very rocky start. With their ups and downs. So with that case. But anywho, we'll figure out exactly what we're gonna be doing. So I guess before we go into any videos or any hearings in regards to this, the first question is, I guess, on my mind was like, why are Mario and Shanna no longer being tried together? That was like, I'm like, why are they not being tried together? And I will pull up the order for us here because the order really does not say. I'll be honest with you, it really doesn't say, but it gives you some kind of insight in why the judge made the decision. So I will show you guys the orders. Yeah, with all the sidebars, right? Let me. I think this would. No, it won't. Okay, no, it won't. Wait a minute. Okay. Okay. So as you can see, here's the order. Let me move me out the way so you guys can see it. So this is the order establishing the trial schedule and also the procedures for the severed trials. Now, she as you can see, all up until this date on this order is going to be, let me see what day she signed it. Sorry guys, let me go scroll down here. So Judge Kite, she actually signed this order on the 28th day of April. Okay, and this, I don't even think that they really, I don't think that Mario and Shanna's defense team even asked for the trials to be separated, and maybe they did. I just didn't find any information on it. But the court did find that it's necessary to establish, pretrial procedures in an orderly way in order to make sure that Mario and Shanna both receive a fair trial. Now, from what this says, they shall be tried separately, the court having considered the procedural posture of this case, the volume of the evidence, the anticipated length of the trial, the number of witnesses, the substantial pretrial publicity attendant to this matter, and the fair administration of justice, enters the following order. So it seemed like because of the case is so big and because of all the information that they have, the defendants stand charged by the indictment in the above style, caused and have been severed for trial by separate order of this court. Both trials shall proceed before the undersigned in the division CRB, in Duval County House. And so then this order, it continues to go ahead and explain to you that we're going to be doing jury selection the week of August 10th, 2026. Sorry, guys. They summons about 250 jurors. They have two phases, so they're telling you what phase 1, phase 2, what that's going to look like. The trial shall commence on August the 17th and is scheduled to continue through August the 28th. So it seemed like they're going through jury selection. From what I can see here, and y'all can correct me if I'm wrong, it says the trial is not to commence until August the 17th. So it seemed like they're going to be going through jury selection starting tomorrow, and they expect that it's going to happen a whole week. Is that what you guys are getting from this? I just want to make sure that I'm into, because sometimes I read stuff and I'm like, okay. But it sounds like the actual trial is not going to start till August the 17th. They will start jury selection. It doesn't seem like they even put the door open for, hey, once the jury is seated, we're going right into the trial. It sounds like they won't go into the trial until August the 17th, but they're going to start jury selection and they're putting a week out for it. So you guys can, I think that's what is going to happen. And then, for Shanna, her jury selection begins the week of August the 31st, 2026, and through September 4th. So her jury selection starts that week. They are going to summons about 500 jurors for hers. Let's see here. Her trial shall start on September the 8th and is scheduled to continue through September the 25th. So it looks like the trial will not start for Mario until August the 17th. Okay. But they'll start jury selection. So we don't have to worry about this trial actually starting tomorrow. So that's good. Because it looks like they have the date for this to want to actually start, not to the 17th. Okay? If we find out something different, then we will adjust accordingly. But right now, it looks like we'll be in, we won't be in this one tomorrow. Good information to know. Cool. Okay. So just to put it in, with this one, this wasn't, like I said, it was not either side begging for a separate child. It wasn't the state fighting them. It wasn't, Shayna begging for a separate child, because some times, like when we seen with the Julio Fulio, they want to be separated. They don't want to be together. They don't want anything for another person's. They don't want you to have no judgment in regards to that. Everybody just agreed in this one, so it made it a good decision in regards to Judge Kite, in regards to her separating the trials. And with her separating the trials, this is our schedule and how things will go. Okay, guys? So there we go with that. So yeah, she specifically found that the severance was appropriate. Now, that was the one thing that I couldn't understand when I went through this in regards to Mario being first. But just so y'all know, Mario is considered first, and the reason why he's going first is because he is designated as he is defendant A on the indictment. Shayna is defendant B, and so they just kept it. That's why he's going first. Because I kept wondering, like, I really, really, really want her to go first, but since he is listed on the indictment, and remember he was arrested like 6 months before her, Mario, speaking of Mario, will go first. So there's no conspiracy. It's nothing that they were trying to do. It's just the judge said that's why she's going to have him go first, because that's how they were listed on the indictment. So it was nothing, no conspiracy behind it. Because I was like, why are they having him go first? For what reason? That was just my personal thing. So I had to look through the indictment to kind of figure out why she picked him first. Because I wanted Shayna to go first. So we have our schedule for that. Okay, and so now I'm going to get up our first hearing, guys, so we can take a look at that. And we will go in here and figure it out. Now, this hearing right here is going to be in regards to the charges that were dropped for his case. For Mario. So we'll see him in court. He got his hair. He ain't got, I don't know. Maybe they had him cut his hair. I don't know what he got in the front of his head. It looked like a bang. But I'm going to let him live if that's what he want to have. Like, if he really want to have the bang, I'm going to let him have this bang. Go ahead. Bang it out, baby. Okay, so right here we are going to be... I should edit this, maybe. I think this is... So I'll edit this and I'll get this together. But let's go in here. Let's listen to him and his pretrial motion. This hearing was on... Let me get the date, because I have to come out of it to get the date. Let me get the date for us so I can make sure I update this right so people can know. Sorry, guys. I thought I had it written down. Wait a minute. It say 12 days. Let me see. I want to say this happened on July the 28th. Okay, here we go. Let me put this in here. That way we'll know exactly what we're watching. 8, 10, 26. And the trial begins. I'm just updating this. Trial begins only so we can, if anybody's coming in late, they can have the information with everybody else. And his trial begins on August the 17th, 8/17. So we have so let's go into our first hearing that we're going to review over today, guys. Now that I got everything set up so nicely for us. So even our people that come in a little bit afterwards, they can see it, right? Yay, 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 yay. All right, guys, let's go. Like, I don't know what's up with this bang in front of his head, but I guess I gotta let him live with it. I don't know what he has.
Morning, Your Honor.
Thank you. Good morning.
Christina Stifler and Alan Mizrahi on behalf of the state. We're here on the case of Mario Fernandez, number 1 on the court's calendar.
Good morning, Your Honor.
Good morning.
My name is Jesse Dreiser, and I represent Mario Fernandez. I'm here along with Ms. Day. Mr. Hill had a federal status conference, which he's doing remotely, I believe, in the jury room, and hopefully he'll be out here in a little bit.
Okay. All right. If you would, today is the court's operating final pretrial, and so I may be addressing your client. If Mr. Fernandez, if you would please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm that testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, thank you. All right, you can be seated. I'm going to talk to the lawyers for a little while, and I'm going to confirm some things with you, okay? All right, so I appreciate both sides. I've been looking at the diligent work that you all have been doing, even as of late, and so I want to kind of take up one thing at a time, which is first starting with, yes. Okay. Mr. Smith, he said I'm muted.
You're muted not at the Zoom.
Okay. All right. And then so I want to take up first one thing at a time. So we are going on the indictment that was initially, it looks like it was filed August 17, 2023. Is that correct?
It is, Your Honor, and this morning the state has filed a statement regarding the indictment. I provided a copy to Mr. Dreiser yesterday. We've been in discussions regarding this. The state will be proceeding on counts 1 and 3 of the indictment.
Okay.
Which is the homicide and the solicitation. I provided a copy of that statement to Your Honor, and I filed with Mr. Hathaway.
So for purposes of the trial, and this is known by the defense, I'm assuming.
It's been talked about for probably 10 days. I got official notice yesterday.
Okay. And so for preparation, instead of filing a superseding document, what I would ask is that the state prepare what we would call kind of a dummy indictment.
Yes.
With renumbering just for record purposes. So 1 and 3 for all of our purposes. So 1 for the official record will remain 1. 3 will become count 2.
You're referring to what you'll read to the
Correct.
jury? Yes, ma'am, I'll have that done.
All right. And then so I guess the state abandoning 2 and 4?
Yes, Your Honor.
Which is the conspiracy and the child abuse.
Okay. All right. So I believe you can interlineate these documents if you want, and then for just so it looks clean, if you could prepare one for me and one for the defense,
Sure.
But you want to interlineate the document that's filed in the court record?
I can do that. Mr. Hathaway and I will confer, but I don't.
Go through this one now.
I assume this statement regarding the indictment is filed, which should sufficiently take care of it.
All right.
It is a joint indictment, so my concern is making any interlineation into Mr. Fernandez's case that does not apply to Ms. Gardner's case. They're on the same indictment.
Okay. So you're going to prepare another document?
Yes, Your Honor.
All right.
And I don't know if she said this, but I do think you would want to know, I'm sorry if you did, their indictment is not being modified in the same way in which ours is. So.
Right.
Correct. Right.
But we're going to have a clean document so that I'm not
I
reading.
agree with that. I just wanted you to know that, that it wasn't the same, meaning.
So what I've done for myself is I've highlighted his name. I was going to only read that portion of it, but it would be nicer for me if I could just read.
Absolutely. I'll make one as if that is the way that Your Honor would read it to the jury at jury selection and trial. I'll provide a copy to Mr. Dreiser for his approval and then forward it to Your Honor.
Okay. And then I did get, I don't know that it's filed though, a statement of facts.
We have agreed on a statement of facts.
It needs to be filed.
Yes, Your Honor.
And
Right, we can file that today, Your Honor.
Okay. And then, so,
oh, can I have one moment, State?
Yes. Hold on.
Practice this.
Still,
I know, I'm working on it. Okay, sorry.
okay, so,
That'll get filed today.
okay, great. And then in looking at the order that I introduced, that I filed, the way that jury selection is going to go forward, phase one, which is scheduled to start on August 10th, I believe that the clerk's office may be prepared to bring up more than 50. Would you all be interested in that or no? You want just the 50 to work through for the morning? The question was posed to me that, you know, if they had 70, if they had 100. I personally think 100 is too much to try to get through in the morning, especially, I'd rather we can hold over some for the afternoon and get to that point, but I want to have people waiting as little as possible.
No one does this more than you. I defer to you on what you think the timing of that procedure would take. You would know better than I would.
The state's thought process, Your Honor, is that as long as the jurors are comfortable and are not sitting on hard benches in court during this process, or sitting on the floor outside, I've had a case before, too many people. So I want to make sure the jurors are comfortable and they're in a position where they're not being inconvenienced. It doesn't matter to me if it's 50, 60, 70, as long as they're not being inconvenienced.
So this courtroom, I think, can comfortably seat, I think, up to 100. But our magic number for questioning purposes is 100. And so we could possibly, I want to have hard breaks, which will allow everyone to kind of keep the stamina of the trial. So noon, lunch to 1 p.m. and like if we're more regimented in that factor, but we'll know from the first group. My suggestion would be we keep to the 50, work through the 50, and if we're done a little bit earlier, okay, you can go to lunch earlier, then we bring another 50, and just be more pragmatic about it than bringing up way too many people and then working over. That would be my preference.
That's fine.
And how, that's fine, but how quickly, let's just say that the first 50 comes up and 5 people say they have a hardship for timing and calendaring purposes, and 5 people say they know something about the case and our line into room 2 is only 10, and the rest go, and they start filling out questionnaires, how quickly could we get another 50 people is, I guess, the question I'd want to know.
Well, they would be summoned for the afternoon, but then you would have, if let's say we finish early, then you would have the time to kind of go over the questionnaires a little bit longer.
Sure. All right.
So it would just be, if we finished a little bit earlier, that would give y'all more time to work and not be kind of under the pressure of questioning more jurors. But I say we kind of stick to that process until we see that how hard or how easy it will be. And so let's say potentially we get the first 50, we're able to work through those individuals very quickly. You'll have a little bit more time as far as a break. We get the next 50, it's a little bit harder because, it's really juror dependent. But the main thing is that we have the groups in here that it's already designated that you're going to have the group that's going to remain in here and then the group that's going to go into the side room where we discuss the hardships, and we can get through those hopefully very quickly. Are y'all interested in my chart for hardships? Do you want that?
Yes.
It's something I do. I'm going to keep my own, but I'm happy to share it with the parties.
That's fine.
Yeah, please.
Yes, ma'am.
Okay, so I developed it, I came up with it last time, and then it just allows notes to be kept, like who stays, who goes. All right, so I'll send that to you all.
And just, my recollection was, once we get 100, we'll bring back 100 that day for actual, traditional voir dire, except once whoever comes back out of that 100 will release X amount of people to only have 70. Is that everyone else's recollection?
No, I think we ended up with
We're going to have 100.
92.
What? We're going to have 100. Because once y'all get to the questioning, I mean, you don't have to question the remainder of the panel, but it would be nice if you're exhausting cause challenges, if you're, like, there are things that you can't anticipate, to have the jurors instead of trying to summon more. But my thought is Monday morning, 50. Monday afternoon, 50. And then I think that we should be able to get to the 100. Definitely, hopefully by Tuesday. That's what I'm thinking. And then Wednesday afternoon is when you start your actual questioning of the jurors. So that you all will have all that time to go over the questionnaires and do your work. And then we will start Wednesday afternoon with the actual selection process. And that's just in case. So if it's too hard, then we would still have Wednesday morning, another 50.
Yeah, and I would like the court to know it's probably going to be the defense's request that if it starts in the afternoon and the state goes, unless they are real quick, I don't think I'm going to want to go that afternoon, break mine up, and have a bunch of very tired people late in the day.
I understand.
Okay.
But they'll be fresh. That's the point of not starting in the morning.
I understand. It'll be dependent on our request.
So, I mean, I do still have, my thought for phase one is that I come out, I do my normal introduction of myself, of the staff, of the parties. That would allow for that kind of baseline questioning. Does anyone recognize anyone? I read the indictment, I read the statement of facts, and then I'm going to publish the trial schedule. I'm thinking this whole scenario would take, I'm thinking 20, 25 minutes. Okay, and then I'm going to tell them that we're dividing ourselves, they're dividing themselves into two different groups. The group one is going to say that they want to be heard as it relates to they've heard something or they think they know something about this case. Group one will also be considered individuals that want to be heard related to hardships or difficulties with the trial schedule. Group one will also be individuals that believe that they know either myself, any staff, or any of that. I'm not taking any questions in a big group. Group two are those that believe none of those issues apply to them and they don't want to be heard, and therefore they're going to remain in the courtroom. The questionnaires are going to be distributed to them and they're going to complete the questionnaire. I'm going to tell them and read to them, what they are essentially swearing under oath that they're doing, because then they need to know the seriousness of it because before I leave. And then once we divide out into two groups, I've already gotten with court administration that they're going to have sufficient number of bailiffs to help facilitate the line where whoever wants to be in during the questioning, will be excusing ourselves. The remainder, we will not be in session in here, but for collection of questionnaires after both sides agree that it is filled out properly, the clerk's office is going to scan and then send those out to the parties. And so depending on those numbers, we'll know how many to kind of, our cutoff is. And then I was going to give them the report date of Wednesday afternoon, but if y'all want to start in the morning, I'm happy to do that. If we think that, we can always summon more jurors to get to the Wednesday morning. Would y'all rather have Wednesday morning report back date? Because I haven't set that for the jurors that have finished the questionnaire.
I think that we should start with a Wednesday report back day, but if we notice from the first 50 that we're seeing a lot of hardships and or media attention.
Just to be able to contact those individuals and move it.
We say it's tentatively Wednesday morning, but then, if we see that in the morning and the afternoon that it's going slower than we anticipated, then we can always bump it back to Wednesday afternoon. So I would tell the jury to make sure that we have a good phone number and that they check it and those kind of things. Or they call in. I don't know, they could do a voice recording like they do for jury selection where you call in and it says, you have to show up at Wednesday morning.
I don't know. From the clerk's office, do you know if that's available?
Your Honor, I know that they can update their message, but it's not standard Monday jury selection message. It's not for this specific panel.
I think my preference is to stay with what your initial thought was, which is Wednesday afternoon. That'll give us the sufficient time that we need to go through the questionnaires and do the work that we need to do outside of the courthouse.
It's up to y'all. It doesn't matter to me.
We are in disagreement. I think that we should use the time. I don't want to rush things. I think the court's plan is great. I think that we should be able, in 2 days, to have 100 people. And I just can't imagine that we're going to have, I guess if we're doing 50 at a time, that's 100. That's out of 200 people that we're going to have half of the people be stricken. Maybe I'm wrong.
And I agree with Al.
Even some of the people that have heard of the case are going to be able to sit.
Right.
And this isn't a situation where obviously maybe some pieces of evidence that they learn about that they cannot sit. But if they're like, yeah, I heard something about a guy shot in Jack's Beach, it's not have any fixed or definite opinions. I think those people are allowed to sit. So I think that on Monday, and if we go slow, perhaps leading into Tuesday, we should have 100. So to come back Wednesday afternoon, I'm not sure that's necessary. But maybe I'm optimistic.
It's not his optimism that is objectionable to me. It's that I'm anticipating the work that we're going to do getting to the 100, and then the work that we need to do to sufficiently understand who these people are. That's the extra time that I'm seeking.
I'll do the Wednesday afternoon. You all can use the time to work on your trial, or we can even use the morning if you need. And like, let's say you've done your work, that if there are any hearings or anything at the last minute, we can come together prior to jury selection.
Yes, ma'am.
And that should still allow us to finish Thursday.
100%.
Yeah.
And then you would have all of Friday.
Friday for me.
And, yeah. My jury selection is not taking an entire day, so
Okay.
I don't believe so. And I still, I don't know why, I'm not trying to push back, it's not that big a deal, but I really thought that we had, when Mr. Mizrahi and I were doing the math with the court, we really were comfortable with 70, and then
If you want to do 70, it's fine with me, but I
said, which I thought was really smart that I didn't think of, was, yes, but when we get 70, there's a chance that when the 70 return, you'll get some illness, you'll get some, I saw the case on the news, you'll get some problems. So I thought you were saying, let's get 100, let's get 100 to return, see who returns, right? And then that'll make sure that we actually have 70 sitting panel, a panel of actually 70 by bringing 100, and then we'll excuse the remaining 13 people or whatever.
So how about we leave it the way it is, 100,
It'll go
okay?
faster.
But however, you all will know from the questionnaires whether there could be an issue and we can keep the 100 or not. Like, you don't know, there's a great unknown about like what people are going to put on their questionnaires. I think that was part of the conversation as well. So we get to the 100, everyone reports back. You all have done your work as far as the questionnaires are concerned. If there is concern that a number of these people may not be able to serve, I do want to get to at least a good solid 70, and maybe the 70 comes out of the 100, and we can say from the questionnaires, these are problems. We can also bring in people individually that may indicate issue on the questionnaire that is not right for the entire group. So I'm fine if y'all want to just question 70, but we're going to bring back the 100. So if you want to seat 70, is that agreeable with the state?
We can just,
Okay,
we can make
all
that
right.
decision that morning.
And then we'll see who comes back out of 100.
Yeah, that makes
Right,
more
and
sense.
then after y'all have, because there's a great unknown. So,
You can have 30 come back and say, I can't do it.
right.
70.
I definitely agree with the 100. We can come to a decision that morning. I think that makes more sense.
So, I mean, you all know,
Thank you.
you all know that in jury selection, generally what happens is they go outside and they start talking to the bailiffs, and they start telling the bailiffs this, or they tell the bailiffs that, and then here we go, losing people. So, I mean, maybe you don't need everyone, so we'll just get to the 100 and we can excuse from there. That's fine. But we'll seat 70. So 30 people will,
When we stand up and go high, we will have 70 jurors, 5 on each row of both sides.
does that make sense to the clerk's office?
Yes, Your Honor.
So we're going to bring back 100, but we're going to seat 70 questioning jurors. Okay.
If we have a few more, be on standby and just be listening, and the parties can bring up the question.
That's what I was, but,
So we can be there in case of something.
All things we can address that morning. Let's see how it goes.
all right, we'll see how it goes.
Does the court know, or maybe this is a better question for the clerk, my understanding is there's 250 like separate summonses going out to the community,
There's way more than that
or
to get to the 250. Yeah.
whatever that number is. How do we know, what's different about the ones that are going for our case versus different from another case?
So the way that it works is that the general summons goes out. They are all called down for qualification. They have to still go through the qualification process. And then from the qualifications, if they are not excused through qualifications, meaning they don't meet the statutory requirements, then at that point in time is when they're randomly selected and put into a list to come up.
Understood. That's when it happens. It's not on the summons. Okay.
No. I said that I was going to go down, but I've talked to some other judges that are going to cover me, so I don't have that extra duty, but there are other judges that are going to assist me in qualifying, so I don't have to be downstairs qualifying. But once they get through the qualification process, they're then randomly brought up. Like, so there's a random juror list that's generated at that point in time, and that's how we get the 50. So that's what I was saying. The clerk's office believes that they can bring up more than 50 out of that random selection, but they're summoning morning and afternoon, and they're randomly selecting out of that group that is qualified.
My suggestion is, we can see how the morning goes, and if 50 takes till noon, then we know 50 is the right number. If 50 takes us till 10:30, then maybe we could bring up 70 in the afternoon.
Okay. And that's all depending, like we have a minimum number that we need, and we can always go above. So I agree with that strategy. Is there anything that you want me to add or subtract from phase 1 about what I intend to do? The introduction of the case is what all I'm going to be doing.
And I'm not requesting this, but perhaps we could include the witness list, since we're introducing everybody. I don't know if that's necessary. I just throw it out there since we're talking about all the lawyers and your honor and all the staff, that maybe we just also throw in the witness list.
Okay, I can do that.
Ms. Rodney, we're not able to hear you on Zoom.
And when we go back into the room for the hardships, Your Honor, you're going to control that questioning and then say, do the parties have any further questioning?
Yes.
Thank you, William.
All right, so if you all, I'm not asking that you file the witness list, but if you could communicate it to my office, and I will incorporate it in the opening remarks. Is there anything else in addition to the case introduction? So I'm really just putting this out there because I did it by order that for the media, it is my contemplation that part of it will be open to everyone and part of it will not be. So if there is, I'm bringing this to the media's attention that I don't necessarily intend to have the media back there with people talking about their hardships, financial or otherwise. But if you all want to intervene, you need to do it by motion. I'm not going to set a separate notice hearing because I've done that in the prior trial order. So from the defense perspective, the state wants the witness list. I'd like to make sure that you share it because there are witnesses that may not be common to both sides.
Yes, Your Honor. I'm also going to put names that they will hear during the course of the trial, even if they're not witnesses. I think that's prudent, given the number of witnesses in the case.
All right, just so communicate,
Yes,
review it.
Mr. Reister and I will coordinate that, and it will include both sides' entirety of names that need to be explored with the jurors, potentially.
All right, I'm on to phase 2 now, which, do you all want me to reread the indictment or no? I don't think that I need to, but I'm asking because there will be days in between.
I don't think you need to.
Does the defense agree?
Yes.
All right. And then, so my phase 2, the only portion that I would intend to cover at that point in time is I'm breaking it up significantly from what I normally do. My phase 2 would look like this, which is you were read the indictment on whatever day prior. Okay. Then I would go into the procedural history that Mr. Fernandez has entered a plea of not guilty and what this means. And then I go through the state has to prove the charges beyond a reasonable doubt. It is now not required, but basically preferential that the trial court read the entire reasonable doubt instruction. Is there any objection to that?
The new reasonable doubt instruction?
Yes, the new one.
No, I was just emphasizing that. No objection.
I was hot off the press. I think I was one of the ones.
You told us about it.
So, yeah. Any problem with me doing that?
No, we usually request it.
Okay, the entire reasonable doubt instruction. Is there any other instruction that you want me to give? I generally will tell them that, what my role is, what their potential role is, which is the judges of fact, and that our roles do not overlap with one another, that the attorneys are going to talk to you all and question about, basically I explain that you all are not able to pre-try the case. I give a silly example, generally speaking. that explains what they have done, what you all have done with their questionnaires and formulating some questions. And when I say still example, it doesn't make any sense that I say lawyers are not allowed to pre-try the case, ladies and gentlemen. And so what they have done is they have taken the information. They know all about this case, but they're not allowed to discuss it with you at this point in time. However, they are going to pose questions to you. They're going to require you potentially to weigh your background experiences, things that you have walked into this courtroom with, to determine if you can be a fair and impartial juror. And then I use myself as an example, and I say if I'm juror A or juror B, depending on my thoughts and feelings, my experiences, I may not be able to be fair, and that I should express that. Or I can be fair, because the experiences I can compartmentalize and base it on the facts and the evidence. But I generally do that. Is there any problem with that?
Not from the state, and I don't think that beyond the reasonable doubt, I don't think there's any need for instructions. I think the lawyers can handle it from there.
Okay. Do you agree?
Yes, ma'am.
Okay, so the role of jurors, the procedural posture of the case, and then I will let you all question from there. So I would anticipate my portion, phase 2, to be about 10 minutes long, and then you all would have the majority of the time.
Yes, Your Honor.
Okay. I just generally forecast that for the jurors, because a lot of times they get aggravated or they start asking the lawyers questions like, tell me this, I don't know, and all that stuff. And so I think that has a lot of frustration. The only other one, I can have them reaffirm or re-instruct them on the no communication if you want me to.
I think that's intelligent. And it's also intelligent to remind them that they're still under oath.
Okay. I'm going to have them sworn in again.
Yeah, so I think that, yeah, staying away from the media, disregarding it is always, I'm sure we'll hear that. You'll probably tell them, you're going to hear this 100 times. So.
I'm going to remind them of what they've signed, and I can, it's more brief, but I can do that. So the communication rules. All right. Anything else that y'all can think of? Did you all look at the questionnaire?
I did.
Yes.
It looked fun.
The revamped version?
I saw the revamped version.
Was there any addition or deletion that y'all wanted to talk to me about?
The only one that I suggested, which I'm sure the court saw and disregarded, was the other significant employment. I always think that that's interesting.
I didn't disregard it.
I can ask it. It doesn't, it doesn't. There's a lot of questions from the questionnaire that we're going to have to go into more detail on anyway.
Agree.
So I don't think it's that. It's not necessary.
I didn't see this. Did you add the handles, the media handles?
Yes.
So I put it
Number 2, I think.
number 3. So it's name, date of birth, social media names and platforms. And then I revamped the residence area, years of residence. The employment, I can add it there if you want, but
It's fine, Ron.
I think the how long may prompt you to say, have you done something more? But-
I'll ask it anyway, Ron. It's fine.
Okay.
Forgive me.
I did add prior military law enforcement experience, prior legal education, I should put legal experience. Education or experience, legal education, or I'll put legal experience just to be clear. So this will be duplicated. This is what's going to be required that you all check prior to both sides indicating before they're collected by the clerk and scanned in and sent out to the parties.
You mean check it to make sure all the questions were answered?
Yes, and that there's nothing in addition that needs to be accomplished before we send them away.
Hypothetically, if a question, if an answer is illegible, or is
Yes.
the bailiff going to ask that question? Who will ask that question of the juror?
So I don't have any problem. I didn't necessarily think there was any issue that, I don't know if you want the bailiffs to do it. What's y'all's preference?
I'll make it for them. It doesn't matter to me. I'm happy to have the bailiffs do it.
So the question is, if something is illegible, or if it's not filled out correctly, I mean, do you want the...
I thought you had instructed us that we should have one of our own team members go through every single one,
Yes.
make sure that we were satisfied with it.
So what if it's not, there's an issue with it?
Yeah, I assume that you wouldn't want our person individually speaking
No.
to the juror, so yeah.
But you both, or you could write the note and the bailiff a note could be written saying section 13.
Sure, and then a bailiff would just say, can you make this more legible, or you forgot this one subsection? Sure.
Yeah, I have no problem with the bailiffs interacting with the jurors.
Okay, so we'll have the bailiff do it.
And then we had emailed on the questionnaire about if someone had worked in any of the offices, state attorney's offices or any defense offices?
Put that in there.
Yeah, I'm sorry, I just didn't print the new one, sorry.
No, it's okay. So this is, I did a slight compromise. I made that suggestion.
I saw the legal experience box.
I thought that would be more general, so that prior military law enforcement experience, prior legal education or legal experience. You don't think that would bring up SAO?
Thinking out loud, maybe dumbing it down to be, instead of experience, working in any law office or something. But that's fine. It's not, I'm overthinking it, it's fine.
Any prior, so what do you wanted to say?
It's fine as written, Judge.
So it says any prior legal education or legal experience. And I thought that might even capture people that interned or instead of saying working.
We have people that went to law school that never practiced.
I thought it would cast a wider net than, but again, you all can follow up on any of that, so.
Yeah, spouse.
Do you have a close friend or relative in law enforcement? Do you have a friend so you want someone, you wanted to say?
In box 10, any prior legal education or experience, maybe you or spouse?
Well,
Any?
if we say spouse, we should just say close friend or relative, because it could be a child or a parent or a sibling.
I just think the more information we have on things that we always want to know, it'll just make the selection go faster.
And that's fine, we can add.
So I have 15. Do you have a close friend or relative who is, I can make that a list. Law enforcement officer, what else?
Attorney,
Okay.
victim advocate.
Do you really
I
want?
think keeping it generic is better. I think just mirroring that language. Do you or a close friend or relative have legal experience or legal education? The way that your Honor's written it, just adding in close friend or relative.
So I'm in 15. I'm in box 15. Do you have a close friend or relative who, and I could put a list if you want, and it says yes or no, and if yes, explain.
And what I think Ms. Stifler was saying, and I may not disagree, is we leave 15 alone,
Right.
but we compromise by adding, going back to box 10, and adding
Close friend or relative.
close friend or relative.
I don't want to do that because I'll add a box under spouse, okay? Because like that's coming where they are. Like all that information is related to them and their employment. I can add a box if you want that under the spouse, it says relationship status, and then it would naturally flow from there. I'm on 11 and 12 where there's a big heading that says relationship status. I could add another box there that says occupation of spouse, and then I could add one there that says law enforcement, close, but then I think I'm duplicating 15.
I would be okay with the compromise of just adding spouse's occupation in box 12 and leaving 15 the same, then you'll hit it from...
That's what I have, 12. Occupation of spouse, employer.
Presumably that will answer the question if they're employed in law enforcement.
Or if they're
Right.
at an attorney's office, that's fine.
I'm going to put spouse or significant other. I'm trying to capture everyone. Do you want to know law enforcement there, or just leave it with 15?
Leave it with 15 is fine.
I'm in agreement with that.
All right. And then the children are covered in 14. Age, sex, occupation. Victim of crime, arrested or accused of a crime. I think I might have you. Okay, 17 is you, the juror personally. 18 is friend or family member accused or arrested of a crime. I think that one was a little bit more significantly different than the one I added some. All right, so anything else related to the questionnaire?
Not from the state, Your Honor.
Not from the defense, Your Honor.
All right, and then I intend to work on a proposed draft of jury instructions. I will get that out to you all. I did see that the defense filed an alibi, which I will include. Is there anything else kind of?
We provided our copy of
Right.
your instructions to defense.
Oh, you did?
Review.
Yes, Your
We
Honor.
can supply that to Your Honor and work off of.
Okay.
We did not include alibi.
I'll forward that.
You do not?
I didn't know you'd file the notice of intent to alibi.
Okay. You know I do the jury instructions, but if you would send them,
I'll send them to court and counsel right now, and then Mr. Dreiser can send the alibi instruction, and Your Honor can at least have those to work off of for the time being.
okay. Anything else that you all, any negotiations that you all want to place on the record?
Your Honor, there's never been a state offer in this case. There has been one defense offer that was rejected by the state.
Okay.
The defense filed a request to take judicial notice. I think there'll be an agreement on that. I just need to provide some information to the state attorney's office.
Okay.
And we filed a motion to eliminate, state filed a motion to eliminate. If you would give us some time on Friday, that would be preferable. We can knock those out.
This Friday?
Yes, Your Honor.
Okay.
I know you have a hearing in Ms. Gardner's case at 10. We could have time after that, maybe at 11 or 1. We have the afternoon. 1 o'clock?
I have a 1 o'clock now from sentencing. I can give y'all 11.
That's fine with the state.
11?
Yes, ma'am?
So is there anything else that we need to cover? I'm going to talk to your client briefly.
We have some stipulations we'll be filing between the parties. One was regarding Vivi's testimony, which I provided to the defense, that we are not calling her as a witness, and a video is going to be stipulated to be admissible. Zoom testimony stipulations, these are things we've previously discussed in front of the court, just officially filing those. A statement of victim identity, I believe the defense will most likely be in agreement with that. And then the defense has filed a motion requesting specific discovery, which I'm in the process of fulfilling. And if we don't have satisfaction on that, we can address it with the court Friday during the motions in limine.
Okay.
I say that because their motion asked to be calendared, but I believe we can most likely fulfill what they're asking for short of a hearing.
Okay. I'll cover the stipulations a little bit later. Have you had an opportunity to talk to Mr. Fernandez about it? I can do it real time with the actual stipulation if you want.
Right. For
You want an answer?
For the Zoom testimony, if they're not in agreement, obviously we have to make alternative arrangements. Now I'm forwarding the jury instructions that the state has prepared to your judicial assistant and CCing defense counsel.
Thank you.
And Ms. Judah with our office, who is very motivated, has been listening, and she prepared a dummy information I sent to defense. And if they approve it, I'll forward it along as well.
Great. Thank you.
Your Honor, at this time, the state would file stipulation by parties for remote testimony for listed witnesses: Taylor Curtis, Abigail Bridegan, George Cruz, and Victor Quiroz.
Thank you. Okay. All right, Mr. Fernandez, you have been present throughout the final pretrial, and so I've got just some questions that I want to make sure that it hasn't passed you by, okay? This is a very important court date for you in the sense that this is the last, almost the last court date that I'm going to see you prior to your trial starting. okay? And so first, I'm going to start off with, did you understand that the state of Florida is going to abandon 2 of the counts that they initially filed against you?
Yes, Your Honor.
So now you will be facing trial pursuant to the indictment that was filed for count 1, which is murder in the first degree. That is a capital offense, even though the state of Florida has abandoned or withdrawn their notice of death penalty. There are only 2, if the jury finds you guilty of that crime, there are only really, there's 1 punishment at this point, which is mandatory life in prison. Do you understand that?
Yes, Your Honor.
All right. And then they have abandoned count 2, but are proceeding on count 3, which will be renumbered, and you, for the remainder of this proceedings, will be for solicitation to commit a capital felony. You understand that?
Yes, Your Honor.
So a solicitation is almost like an attempt. So it takes it down 1 degree, 1 level from what they would call a quote-unquote target offense. Do you understand that?
Yes, Your Honor.
So it takes it down from the capital to the first-degree felony. Am I right on that? No, life. It's a life offense.
Yes, Your Honor.
All right. So I'm looking at the MCL number. So it takes it down from the capital offense to a life offense.
Yeah.
Punishable by life, yes. You understand?
Yes, Your Honor.
All right. So it's important,
That's, I think it's a first-degree felony.
on the MCL it says 3. It's a first degree. It's 1. Okay. So what is the life offense?
That's what I thought it was.
Are you looking at the MCL?
One moment.
No, you're right. First degree felony.
Yes, Your Honor.
Which one? 30 years.
Up to 30 years, level 9 on the
Okay. All right. So first degree felony. So to summarize, count 1, capital offense. Okay. Count 2 now, formerly 3, is a first degree felony, punished by up to 30 years. You understand that?
Yes, Your Honor.
Okay. So it's important that you understand what the state of Florida has charged you with, okay? But by exercising your right to a trial, not entering a plea, what you are doing is you're preserving your not guilty plea. You understand that? And you are presumed innocent of these charges, no matter how weighty they are, okay? No matter how many years that they could potentially get because they haven't proven anything in court. Do you understand that?
Yes, Your Honor.
All right, so pre-trial, this case has been going on for some period of time, all right? And it's important for record purposes, not that you have to, nor are you required to, but if there was any negotiations, that will never come in during the course of a trial because you have preserved your presumption of innocence by exercising your right, but the state of Florida indicated that there was 1 offer made. Okay, is that true? To resolve the case. Did the defense make an offer or not?
I would not consider it, it was not formal, it wasn't in writing, it was more of a discussion, and we certainly do not want to discuss it in open court.
All right. Well, from the state's perspective, they thought that there may be some avenue for resolving this case short of trial. Let me put it like that, okay? And they've rejected whatever the discussion was, that they are not interested in it, okay? Is that pretty much your understanding?
Yes, Your Honor.
All right. Now, I've been talking to the lawyers about how this trial will be progressing, kind of giving a preview of what the jury selection would look like. It's going to be conducted due to some of the interest in the case in 2 different phases so that we can get to a good questioning panel, okay? That's where your lawyers are going to be asking the substantive questions of the case, but we're going to handle phase 1, which is hardships and people that think that they may know something about this case. Do you understand that procedure?
Yes, Your Honor.
Okay, and so also by the time that we get to the trial, your lawyers obviously have been working on this case, investigating this case, representing you throughout this entire process, and once the trial starts, there have been stipulations, which are agreements by lawyers, and I want to make sure you've signed this here in open court. I'm going to go over each one that refers to a witness, Taylor Curtis. Is it Jorge or is it George? George Cruz, Abigail Bridegan, and Victor, is it
Quiros.
What is it?
Quiros.
Quiros. You have certain constitutional rights that this implicates, which is the right to confront witnesses, okay? The way in which confrontation occurs, generally speaking, is in open court, all right? But by the invention of Zoom and the invention of remote technology, it can be utilized during the course of a trial. Have you gone over that with your attorneys?
Yes, Your Honor.
All right, and I am going to tell you that I'm familiar with the law that is required, that is that you, even if you have agreed to this, which I'm going to get to in just a moment, if this goes forward, this is going to be the procedure. I'm going to tell you because it's required by law, okay? Number one is that you can see the witness, okay, very clearly. Two, the fact finder, the jury, can see the witness, okay? Number three, the witness can see you. All right? And so those three parameters at a bare minimum have to be satisfied. So it's as if they are in a courtroom of law. And then what also must be impressed upon, so I will allow this procedure, but it also needs to be impressed upon the witness. The other component of that is that the witness is in a location that impresses upon them that they are in court, that the seriousness of their testimony is impressed upon them, that when they take the oath that they know that they are swearing by penalty of perjury to give appropriate testimony, just like any other witness. So they need to be in a setting that is stationary, stabilized, not noisy, those types of things. So the witness knows, okay, when everyone's seeing, okay, that they know the seriousness for which they are testifying. You understand that?
Yes, Your Honor.
Okay, so I'm sure your lawyers have gone over that with you, haven't they?
Yes, Your Honor.
All right, and have you, and I've seen you sign this in open court, have you had time to consider that?
Yes, Your Honor.
Would you be in agreement with that procedure?
Yes, Your Honor.
Okay. Did anyone threaten you or coerce you to stipulate, along with your lawyers, to this procedure? All right, I'll accept each one of the stipulations as freely and voluntarily entered. There are other stipulations that may come up, but these are the ones I'm going to cover today because it requires planning purposes. All right. Is there anything else from the defense perspective that you want me to discuss with Mr. Fernandez? I think that was it for me.
No, ma'am.
Okay. So just so that you know, this jury selection, we're hopeful that we can be done with it in short order. But I think that you have not been present. The times that we're not necessarily working with the jurors will be time that your lawyers will be working with you, okay, and throughout that process. And just for trial scheduling purposes for the lawyers, I'm going to try the best I can that we are working normal working hours, okay? And I think it helps everyone with the length of this trial and the amount of information that they're going to have to kind of deal with. I'm going to give like full notepads to them. Is there any objection to that?
No, Your Honor.
I'm going to allow them to take notes. I think I shared my preliminary instructions with you. Was there any objection to those? I can resend them if I need to.
I'm sorry, say that again, Your Honor.
The preliminary instructions. I think I explained, I take the standards, but I reorganize them to the way that...
That's fine.
No objection. No.
Okay, was there any objection to the preliminary instructions that I give? It includes notes. It is discretionary whether jurors can ask questions. I was not going to give them that option, unless you all want to be heard about that. Jurors questioning witnesses.
No, Your Honor. No objection to not allowing that instruction.
Okay. So it would just be preliminary instructions and then the notes instruction, and then it would be given out opening statement.
One moment, Your Honor.
Okay. Do you want me to resend the preliminary instructions? It's different than the standard. No?
That's fine. Thank you, Judge.
I have just a last order of business, too. Okay. Did you want to be heard about the questions? Because I wasn't going to let them ask.
No, we do not want to be heard.
I'm sorry?
We do not wish to be heard on that.
Okay, so you're fine with no questions by the jurors?
Yes, Your Honor.
Okay. The last thing that I was going to cover is, was there thought, I've got to file some administrative orders for the clerk's office because there will be interest in this case, and have y'all thought through, I'm going to file the order to keep the names of the jurors confidential. I think I've discussed that with you. Is that also still the party's request instead of sequestering?
Sure.
Yes?
Yes, Your Honor.
Okay. Then the clerk's office, you all have gotten with them, right, about potential pre-marking exhibits?
I spoke to Mr. Hathaway this morning. I know that the clerk's office has been in touch with both parties. We've conducted an evidence view and exchanged evidence lists. So we have a multitude of exhibits we've agreed are going to come in by stipulation so the clerk's office can pre-mark them.
The last thing I'm going to put as far as evidence is concerned on the party's agenda is that I don't know the nature of your evidence or what it's going to take up in the courtroom, but I would request that if you need additional tables that you get with or places to store, that you all get with the court administration and make sure that those that is available to the parties. The next thing is that there will be requests, and I want to allow for organization purposes. I've got to put in an order related to how the evidence will be communicated once it is admitted into evidence. There will be requests for the clerk's office. Correct me if I'm wrong. I think that's what we discussed, that generally speaking, there's a request but to the clerk's office to make the exhibits available.
For the jurors?
No, to the public.
Media?
Have you all thought through that?
Not really.
No, Your Honor. I mean,
I need you to.
Other than we discussed the publication of sensitive photographs during the live stream, but
I need y'all to do that, because what's going to occur is sometimes, like when y'all stipulate, they become the clerk's office and they become public record potentially. So I need you all to make filings about how you want, because I don't know what your evidence is. And so for me to administratively control that and not have to deal with it during the course of the trial, I need you all to research that and figure out what your positions are and file your papers so I can do that.
yes, Your Honor.
Yes, ma'am.
Okay. So you may want to look at some of the cases that were tried. There were high publicity cases for the motions that were filed, but my understanding, once you stipulate, once they become clerk to the clerk gets requests to disseminate those things. Okay?
I'll discuss with Mr. Dreiser and Mr. Hill.
All right. So if we can address that, I'll table that for right now.
Yes, Your Honor.
But the jurors, I'm going to go ahead and enter that order because we're not going to sequester until they start deliberating, correct? Is that still the thought?
Yes, Your Honor.
Yes.
Yes? Okay. Okay, I think that was it. You wanted to cover something.
We have access to the courthouse on the weekends because we come in for J1 regularly. I don't know that we have access to a courtroom the weekend prior to either a jury selection or more likely maybe the following weekend. I would envision it would be helpful if we could come and drop off a bunch of boxes and folders and things like that, so the day of we're not like schlepping, bankers' boxes in here. So I don't know if there's a way we could contact somebody at security who could maybe buzz us in for our closet or something like that.
Don't you have a conference room?
In the courthouse?
Yes. I think Ms. Janako is giving you all a conference room.
I didn't know if it was going to be just that.
No, that's a jury room.
But they're going to be deliberating on that side, so I didn't know if that was going to be our conference room.
No.
Okay. But then, yeah, if we could have access to that.
So you, if you would contact Ms. Janako, and she can make arrangements to have you all in here the weekend prior, whenever you want to. You just make an appointment.
Great, thank you.
And then she can coordinate with the bailiffs. And my understanding, I'm not exactly sure where your conference rooms are, but you're going to have conference rooms available to you. So you're not in the courthouse or in the courtroom. You can have someplace private, and you can store your boxes there, or I think that would probably be more secure than
Great, thank you.
in the courtroom. But I'll let you go. If I need to be involved, let me know.
I can email her.
Is there anything else from the state's perspective?
I don't believe so. Can I have one moment, though?
You want to involve the state? Looking to see if they have anything additional. Did you have an idea of what your daily schedule is? You said you do basically full board. Do you know what that looks like on the start time?
All right, I'll be available to the parties at 8:30, but we would start if the parties anticipate any issues, I can always come earlier. But I want to start with actual court proceedings, 9 to 12, and then pick up in the afternoon, 1 to 5. And so the jurors would have a 9 to 5 day, every day. But I'm available starting in August. I generally get to the courthouse anywhere between 7:30 and 7:45 every day. So if y'all needed me earlier, you can always get me.
Great. All right, well, thank you very much. If we don't have anything further, we'll see you Friday.
Mrs. Stifler, did you?
Nothing
Okay.
to say.
All right, thank you all very much. Court's in recess.
Okay, so that is our first hearing. And for people that were that kind of arrived late, just to kind of recap what we heard in this hearing, we were discussing a lot of things in regards to getting our jury selection together and how this trial is going to go. So beginning on August the 10th, 2026, we are going to bring in a total of 100 jurors. And they were kind of like debating in regards to if they want to bring 50 up or 100 up. And kind of the process is that they're going to check and see who has hardships. They're going to go through the questionnaire, see who knows who doesn't know who. Remember, because they have to do this twice. The first hearing is going to be for, the first trial is going to be for Mario, and then, you know, Shanna, the ex-wife, I guess the ex-wife to him and the ex-wife to Jared, they will, she will be on trial next. So they also talked about the charges, the 4 charges that he had. So right before trial, prosecutors dropped the charges and dropped the conspiracy charge, and they also and the child abuse charge counts. And the child abuse accounts were for the baby, the 2-year-old that was in the back seat, guys. So leaving the most 2 serious charges in regards to this, he still has the first-degree redrum and the solicitation to commit capital felony. Both sound like LWOPs to me. I don't think they have parole. I don't think Florida has parole. They did decide that they're not going to be asking the jury. The jurors are not going to be able to ask questions. I don't know. No, I mean, it's okay. I don't know how I feel about, I don't know how, I would like for them to ask questions, but it is what it is. Most trials, they don't. And it's so crazy because the trials that are able to ask questions, they must don't know how rare that is because they don't ask them. So, so that's the first part of his hearing. And then y'all heard him talking about stipulations, guys. And that's in regards to people that are going to be actually testifying remote. I know Shanna and one of the twins I know is going to be testifying remote, allegedly. And we're going to go over some of the motion and limines that they did file in regards to her testimony very shortly. Now, we do have our next hearing that we're going to get into. And this one is going to be dated from July the 3rd. This one is going to be dated July the 31st. For some reason, what happened was they did this, and you heard how the judge was like, well, you know, she was telling Mr. Fernandez, like, this will probably be the last time that we'll kind of see each other, you know, until trial. But it ended up not being the last time because they end up filing some motions. So they actually end up meeting again, and actually 2 more times because they also met last week on the 4th. So let me get that hearing up for us to watch and take a peek in to see. This one was, so whatever they thought they was going to do. And I love how it seems like she's trying to be as organized as possible to keep this once we get in trial so this can run smooth. She says she'll be there early between 7:45 and 8 o'clock. So if any issues or if the attorneys need to address anything, let's address this stuff before my jury gets here. Look, jury, we going from 9 to 12. You will have lunch from 12 to 1, and then we going from 1 to 5. We working 9 to 5 every day, baby. I like it. I like it. I like it. You know, it keeps the trial. It seems like she want to run a tight ship and she want to get all this stuff out the way. And mind you, this case is not like a new case. This case has been since 2022. The incident happened in 2022. The first arrest that happened in the case was 3-4 years ago. You know, although our hitman decided that he wanted to withdraw his plea. I don't know why Henry did that. Like, for the life of me, you know, my head was spinning last night after we finished our coverage from yesterday in regards to Henry and listening to him talk about that he wanted to turn down the 15 years. And I still am questioning, like, how are you turning down the 15 years, guys? They have too much on him. We have the payments that were sent to Henry, $2,000, $3,000, the whopper of $5,000. Talk about Kickstarter. Good luck. I don't see why he's turning that down. Do you think that because he just didn't want to testify against Mario and them, they're not giving them any, like, and just so everybody knows, no, Mario is not being represented by a public defender. He is actually, he's paying for his attorney. And Shanna is too. So I bet you the only person that got a public defender is going to be Henry. He the only one probably got a public defender. I bet you. So the next hearing that I'm gonna be showing is gonna be the one for July 31st, where we're gonna be taking care of some additional information in regards to getting prep for this trial. Like I said, she thought that was gonna be the last one, but it didn't end up being the last one. So in this one, let me tell y'all what stuff is gonna be reviewed over. I'm really liking Miss Kite. And when they was procrastinating and trying to delay this case some more, boy, she was hot at one of these hearings. That's what I will tell you. So the July 31st one, I don't know if he comes in, but it does seem like they do have where defendant was present, but he was in jail. He has on July the 28th, they actually did a motion in limine in regards to some testimony coming in. The defendant also filed a motion for supplemental discovery and request for a specific Brady and Gigolo material. So we'll see about that. Of course, we already know that on the July 27th one that we just heard, she put the order in regards to them dropping the conspiracy to commit the redrum and also drop the child abuse. Both parties in the hearing that we just heard, they did stipulate to testimony from one of the twins that will be remote, so they don't have to go into court. So the baby girl, she's not going to have to come into court. She's going to actually testify from some type of method of Zoom and that's why she was saying that, they have to be able to see him. The jury has to be able to see her, and the court, he has to be able to face his accuser. So they stipulated to that being okay. They also stipulated to Jorge. I think his name George. It may be George. I'm probably just calling him Jorge. Okay, George, he's going to be testifying remotely. They also stipulated to Taylor testifying remotely. Who else is going to do? So those are the three that are going to be testifying remotely so far. They do, I know it's the daughter because I can see her name. I won't say it here, but I'll let you guys do it in regards to that. Let's see here. Okay, so let's go into the July 31st one. This is where they're going to talk about, they should talk about in this hearing, well, we'll go in here. They're going to be discussing probably the motion to suppress some cell phone records. We will also be talking about, his team adopted a motion that was filed by Shanna's team in order to exclude the 2-year-old. Well, she was 2 at the time. Now she is probably 6. She probably 6 or 7. His daughter's testimony, the 2-year-old that was in the back seat. So that's going to be talking about this motion. It was actually filed when their trials were joined together. Okay. And now they are separated. So she has to handle it up under each person's trial. What I can do, let me get it up here. So before we go into court, y'all kind of see what they're talking about. And you guys can even say if y'all, what you guys think about it. Let me get the motion up. Give me 1 second. Okay, I don't want to go over Shanna's. Let me get off my phone and send it over here. Files. Oh, shoot. Let me airdrop it over here. Okay, and then we can go over it real quick, and then we'll go into our second portion. Let me open it up. Oh, okay, I did have it. I thought I had it on the computer. I'm like, where is it at? Okay. Let me get it pulled up big for us, guys. So as I stated, this motion was actually filed up under Shanna Gardner's up under her case, but at the point in time they were kind of joint. So what happened is Mario's attorneys was like, yeah, that's a good idea. We want to adopt the same thing. So we just want to attach ourselves to the motion. And that's what they did. So let me pull myself out the way a little bit. Okay. Trying to get my thing over here, but it don't want to come over here. I don't know why. I don't know what makes it go over there. Okay, there it go. Because I'm like, I don't know what makes it go over there, but it goes over there. Okay. So as you can see at the top, this was filed back in April 15, 2026. We'll see where the order put in as mute. And that just means that the judge put in mute, and that means that they, that's what she kind of decided at that time. And it just basically means that they handled it in a different type of way somewhere, where she didn't have to write up an entire order, okay? So right here it says, Ms. Gardner, and hopefully y'all can kind of see it, is charged by the indictment for a first-degree redrum, solicitation to commit first-degree redrum and child abuse. These charges arise from the fatal shooting of Jared Bridegan that occurred on February the 16th, 2022 in Jacksonville Beach, Florida. Mr. Bridegan was shot and killed after he exited his SUV. Okay. The state has listed blank the decedent as a Category A trial witness. Is also named the victim of the child abuse charge, and I think this is how they getting her away from testifying, guys. And you notice they dropped the child abuse charges. So if they drop the child abuse charges, this may take away baby girl being more traumatized and coming in and having to testify. Okay, so I think this is, I'm kind of putting together that this is maybe why the state dropped this, okay? It says, at the time of the shooting on February 16, 2022, blank was secured in a rear-facing car seat in the rear passenger side of the vehicle. They do show the photo of the car seat. I don't know if it's down here at the bottom. The shooting occurred outside the vehicle near the driver's door. The physical positioning of the child makes it highly unlikely, if not impossible, that blank could have visually perceived the shooter or the events as they occurred. And I can kind of agree with that, right? And I'm hoping that that part, kind of saved her from being traumatized with seeing that, because remember her car seat is facing backwards, and maybe, I know when bystanders came to remove her from the car, she was crying and yelling. Maybe it's because of the noise, the noise from, because I'm assuming that the pew pew had to be loud. During a recorded child protection team interview on February the 18th, 2022, by trained child forensic interviewer Blank, provided statements indicating an inability to describe the shooter, and in response to the prompts regarding the shooting, invoked fantastical elements, including referencing a unicorn, kitty cat, and Arendelle, the fantastical city from Disney's hit movie Frozen. She also referenced that Blank was in trouble with a dog on the night of the shooting. She attached the transcript of the attached child protective transcript interview. So I wonder if they attached that to here. It says, under Florida law, witnesses are presumed competent. However, when competency is in doubt, particularly with a young child, the court must conduct a competency inquiry. Ms. Gardner agrees that the competency is fixed when a child is offered as a witness and not when the facts testified to occurred. So they had it looks like the child protective team interviewed baby girl, and unfortunately, she only 2, so she kind of, relating it to, a Disney movie in regards to Frozen and different characters in there. So it's just saying that she may not be able to be, her competency because of her age, right, won't give her the ability to be able to remember those events, to provide good testimony. Okay. So it say, in addition, and I'm just kind of skipping around here to the important parts for our purposes. It says, in addition to the lack of the competency, she lacks the ability to observe the shooting. A witness may not testify to a matter unless sufficient evidence supports a finding that the witness had personal knowledge. So they're saying because due to her rear-facing position, the child could only have observed could not have observed the shooting. Her CPT interview further supports that she did not observe the shooting and, at best, only heard gunshots, okay? So finally, even if the court finds that she's competent to testify about hearing the gunshots, her testimony should be excluded up under Section 90.403 Florida Stat. Evidence that creates an undue risk of inflaming the jury must be excluded. So they saying that even if she does do that, like, look, that's just going to infuriate the jury knowing that a 2-year, and they will know, but just hearing her happen to testify for it. The emotional impact of Blank testifying at a tender age of approximately, I think she like 6 and she was like 2 then, about the events that occurred when she was 2 would be significant, but practically, there is no need for her to testify. There are videos in the state's possession from homes that capture the sound of the gunshot. So they saying you don't even need her because it's captured on video surveillance from somebody's Ring camera. Okay, so it's another way that the state can prove that. And that the testimony of hearing the baby girl that was in the back of the car is unnecessary. The bystander who removed her from the vehicle has been deposed and is available to testify. There are photographs of the car seat in the vehicle. There is no dispute that she was in the vehicle. So they're not disputing that. There is no dispute that Bridegan was shot and killed outside of the driver's door of his vehicle while baby girl remained in the car seat. So it just provides unfair prejudice stemming from in-court testimony outweighs the probative value of her testimony, and this court must exclude evidence that inflames the jury. Okay? So they asked the court to thereby exclude this testimony. Let's see if, so here is the interviewer. When they interviewed her. So this is the transcript from that portion, guys. So Lori Armstrong with the University of Florida First Coast Child Protection Team interviewed on February the 18th at 10:52 a.m. I'll be interviewing, of course it's redacted because it's a minor. She said, "This is my hangout with the kids' office. You want to come sit in a chair for me?" Baby girl says, yeah. All right, well, blank, how old are you? Baby girl gives her age. Your blank, can you sit in the chair for me? Yeah. Okay, perfect. And you can sit in this one. Perfect. All right, how old are you? You're, so it just sounds like, and just she answers. She said, what do you do for fun? Oh, how cute. She said, I eat cake at my birthday. Oh, you ate cake on your birthday? When's your birthday? I guess she must have answered that part. Okay, and how old are you going to be on your next birthday? She answers, okay. Well, do you know why you had to come hang out with me today? Yeah, why? Because, okay. Why is there a mirror? So I don't know if y'all want me to read through this. I don't know. Do y'all want me to read through this or y'all okay? Because this is just baby girl's testimony. She said, okay, well, tell me about getting a checkup. Getting a checkup? Yeah. Why is he getting a checkup? I've been in the car and I was crying. You were in the car and you were crying? She answers, yeah. Why? Because I hear a boom and the doctor's office started. Oh, okay. What was the boom you heard? I took my jelly shoe off, and he said he had boom, and it's super loud. It was super loud? She answers, yeah. Where was blank at the time that you heard the boom? Got out of my car and was on the sidewalk. He got out. Why did he get out of the car? Because blank got on the road. Why did he get out on the road? Because blank got out of my car and run away. Oh, okay. So he run away? Yeah, from what? Like blank out of the car, we took the big car and got out of the big car. Okay, he got out of the big car? Answer, yeah, okay. Did you see anybody else? Answer, no. No? Okay. Answer, there's just people. Question, okay, what people did you see? Answer, I didn't see Lovey outside. Question, you didn't see what? Answer, a Lovey. Answer. Question, a Lovey? Answer, yeah. Question, what's a Lovey? Answer, she's a unicorn. Oh, okay. Question, then did you say anything before the boom happened? Answer, no. Question, no? Question, okay. Before the boom, was he happy, mad, or something else? Answer, like mad? Question, okay, what does that mean? Answer, when blank gets mad and helps him, he had boom. Question, oh, okay, so blank was mad and then you heard the boom. Answer, yeah. Question, what was he mad about? Answer, or something else. Question, it was what? Answer, something else. But I don't want to say question, but she says, okay. Answer, how about shakes? Question, say what? Answer, shakes. Okay. Answer. And then, what were you guys doing before you heard the boom? Do you remember? Answer. Yeah. What were y'all doing? Answer. I'm not sure. Kitty cat. Question. Huh? Answer. Kitty cat. Kitty cat. Okay. Question. Did Blank get in trouble with anybody? Answer. A dog. Question. A dog? Okay. All right. Now, when you heard the boom, did you see any other cars? Answer. Yeah. Question. What did you see? Answer. Somebody gave me a little baby blanket. Answer. I mean, not question. I guess question. Well, she just responded. She said the person that's interviewing said, okay. Then baby girl says, and I hear a boom. And then the person that's interviewing says, okay. Then baby girl says, and somebody keeps me safe. Aw, this is so sad. And it goes on and it goes on and on and on. I see. She said it's called a paintballing gun. Wow. So that is that's her complete transcript. I'll leave that alone because we know she too, and yeah, it's about breaking my heart trying to figure out how her answers, and it's like she want to tell it, but she don't know how to kind of express it. I wonder like if they ever asked them, like, I don't know how they interview 2-year-olds, for the most part, but wow, how heartbreaking. What a dweeb. Okay, so but for my crew that really, really likes to do to go into all of that, I will once we get finished, I am gonna make a tab for our trial because we know we got 3 defendants coming up. And I'll put this in there. So if you guys wanna, go through there and read it. I'll make sure you guys have access to it up there on Discord. If you're not part of the Discord, please make sure that you will get the link in there before our stream ends. And if you want to become part of that community, that's where we put documents and different things as we're going through trials and as we're discussing things if something comes up. And that's also where Crime Club happens, where they watch movies and all types of stuff. It's kind of like Fight Club. Let's see here. So I do have our next hearing that's going to be up, and we will look at any motions that are handled. He is not in here, just so you guys know. So it's really just the attorneys, and we're dealing with some of these motions, just like I just stated, the one that we just heard. So let's go into there and get into our hearing.
Good morning.
Good morning, Your Honor. Patrick Rody and Kirsten Nelson are present for Shanna Gardner. I believe Mr. Baez is present via Zoom.
Good morning.
Good morning, Mr. Baez.
I'm telling you one thing, I haven't really seen Jose Baez actually in a courtroom or trial case since Casey Anthony. Now, I'm not saying that he has not did a case or anything since Casey Anthony, but I almost can't wait to see him in action to see how he handles this case. Because I tell you, I don't know. Y'all tell me, have y'all seen him in any major cases since Casey Anthony? I know that I know he was appointed or, but I think that he like dropped the last case that I heard he was in. I almost thought he had dropped this case because I hadn't seen him, but he got a team of people. So there's that. But, shit, after Casey Anthony, I was mad at him, but I did, oh man, yeah, there's that, but yeah, shout out to Jose Baez because boy, he got off a good, he made magic in that case. So if you believe in magic, I don't know, maybe he can get Gardner off because, baby, he sure did it for Casey because I just knew she was guilty. I knew she was guilty. You couldn't tell me she wasn't guilty. And Oh my goodness. Yeah, I know, Gabrielle. I heard he had her working for him at some point in time because her mama and them put her down, but I don't know if they relationship better now, but yeah, Casey Anthony, she should have been all the way up under the jail. And somehow, I don't know what rabbit he pulled out of what hat, baby, but he pulled it out. I know. Yeah, she was going to be guilty no matter what. Yeah. 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 But he got her off. She ain't have to spend the rest of her life in jail. So I can see, I don't know what he's spending. But he spent it. So let's hear how Jose Baez is going. Yeah. And I'm telling you, he probably working it. Work it, baby. Work it. Like Pretty Woman. Every time I say that, I think about Richard Gere and Pretty Woman when she was going to go to his car and her friend was like, work it, baby. Work it. All right, y'all. Here we go.
Your Honor, as a preliminary matter, I've had an opportunity to speak to the state regarding juror anonymity and protection. I would make an oral motion, which I believe the state agrees with, pursuant to Rule 2.420C9A1 and 2.450C9B and C to the Florida Rules of Criminal Procedure, that the court take certain action to protect the jurors' information during jury selection and thereafter during trial. I believe the court can enter an order protecting the juror anonymity and their confidentiality and apply means that would be reasonably restrictive to protect the interest of the trial in Ms. Gardner's case.
Okay. And is the state in agreement as well?
Yes, the state joins in the motion and has no objection.
Okay. Thank you for doing that. I know Ms. Gardner's jury selection is going to be after Mr. Fernandez, but I will be able to enter the appropriate orders prior to her trial. So I appreciate that housekeeping on both sides.
Thank you, Your Honor.
All right. And so, Ms. Nelson.
Good morning, Your Honor. Kirsten
Morning.
Nelson on behalf of Shanna Gardner, who is present.
All right, we are here on the subpoena, the motion for a subpoena ducis tecum in Ms. Gardner's case, and I know this has been multiple hearings, and so in review, I kind of started from the beginning, reread the information, and I knew that at least for the public portion of this hearing, if the defense could again, just identify the sensitive nature that you are requesting that the court take in camera pursuant to Rule 3.220M.
Yes, Your Honor, and thank you for the opportunity. We are requesting that the court consider certain matters in camera because they directly relate to defense theory, more specifically, the defense's intended theme at trial. So what the facts and the evidence we believe will show at trial, and the state does not have a right to discover that pre-trial, nor does Ms. Bridegan, who may be subject to the cross-examination that would help the defense in order to develop those themes before the jury. These are constitutionally protected rights under the Fifth and Sixth Amendments, due process, and the right to confrontation. For those reasons, Your Honor, we respectfully request that the court consider in camera a defense submission regarding theory of defense and corresponding exhibits.
Okay. Is there any objection related to the not argument, but in camera examination related to those sensitive matters related to the Fifth and Sixth and due process?
Your Honor, Steve Siegel on behalf of the State Attorney's Office with Ella Mizrahi and Christina Stifler, Assistant State Attorneys as well, on the representation that we're talking about a written submission to the court in camera based on 3.220M, the state doesn't have an objection to an in-camera submission of that nature.
Okay. And so what I intend to do, we've got to fast forward this process. Otherwise, it's going to be disruptive to, I believe, Mr. Fernandez's trial. And so the matters that I took under advisement, I'm going to consider the in-camera submission by the defense. I will have an answer on Monday, okay, related to the subpoena. And then I did need to check in with Ms. Bridegan, Mr. Clifton, on the court's resolution of EF. What is?
Mrs. Bridegan has put together those messages. I can provide them by any means that the court would like me to. If it's going directly to the court, the state, of Your Honor. I want to provide it.
Let me look back. I think I was going to do an in-camera inspection, correct? So she's already put those together?
Yes, Your Honor.
Okay. How fast can she deliver those?
We could probably get it done this afternoon, I would hope.
Okay. I'd ask that I will do the in-camera inspection of EF's, that resolution, if you could deliver it to the court this afternoon. I'm hoping that I can work through that.
It's a series of screenshots. It's okay if I do like electronic files with the JA, or do you want it printed?
Is that how it is? Like, you don't have to print it?
Yeah, it's an electronic file right now. Screenshots with her phone, she'll send me the file, and I can just forward it on.
Okay. Could you do that, please?
Yes, Your Honor.
All right. Electronic is fine.
Thank you, Your Honor.
All right, so as far as the subpoena, I'm going to pass the matter over to Monday. I'm going to consider the in-camera portion of it and then resolve the remainder of the subpoena request, okay?
Understood. Thank you, Your Honor.
Your Honor, is there going to be a separate hearing on Monday, or is it just an order coming out? I just wasn't sure if I have to be
In
here.
order, I don't think that you have to be here. And then if if there's objection to the order, then, or any other preservation requests, then I can hear those. But I'm hopeful. Mr. Siegel very succinctly said I should deny it. So I hope to get, based on the review, get to a point where I can rule. Okay, thank you.
And Your Honor, defense counsel will not be available on Monday. So to the extent that the court is setting a status, we respectfully request to waive Ms. Gardner's appearance.
Okay, that's fine. And if you want to have a member of your team, or I could just issue Monday and not set it on the calendar, I could do that. Just knowing that I'm gonna get it done by Monday. Okay, and if you all want me to come to court or you want to address anything with me, you can add it on. Would that be more acceptable since you're of your unavailability
That works for the defense.
about the state?
That would be fine, Your Honor.
And then Mr. Clifton, is that okay with you? Okay, so I'll make sure that I service all parties so that if you do need my time, then you can add it on, okay?
Thank you, Your
Your
Honor.
Honor, I just had one more matter. We received this morning a additional filing from Ms. Gardner's counsel regarding the issuance of the subpoena ducasticum. It was essentially a reply. I would just like the opportunity to respond to it. I can get you something hopefully later this afternoon.
That's great.
Over the weekend. It won't be long, just a few arguments that I'd like to respond to.
Absolutely.
Thank you.
All right, thank you.
Thank you.
I thought one court figure said it's in the jurisdiction.
We need to pick a final pretrial date for Ms. Gardner's case. Hopefully not overlapping with the trial. Or if you all want, I mean, you can come, we can do like an 8:30 for Ms. Gardner. If there's some last minute issues that need to be resolved.
Judge, I think that would be fine. An
Do you
8:30
have-
at some point.
Okay. Can you all we can always move it, but can we have a target date?
I was going to suggest August 27th, which is a Thursday. Based on my discussions with the Fernandez team, we're hoping to be completed with trial by that date, so we won't be on a time crunch if we set it that
Your
morning.
microphone.
It's on.
Okay.
Judge, that works.
You want to come that close to the jury selection date?
Yes, Your Honor. I don't want to come while we're in the midst of our other trial.
That's fine.
That's fine, Judge. And I think the parties know that if something comes up, we can always ask for a court date.
Mr. Carodi and I were discussing some housekeeping matters this morning. We have some Zoom stipulations we're still finalizing, but if there's an issue that requires the court's attention, we should know that next week, and we can always ask for additional time prior to that.
Okay. So the next court date for Ms. Gardner will be, that's August 27th. It's a Thursday. Do you want 8:30 or you want 9?
I'll defer to defense.
Judge, I would prefer 8:30.
Okay. 8:30 a.m. Final pretrial. And then we'll keep the jury selection dates and trial dates. I do plan to be in communication with the parties with Gardner, the more that we learn from Fernandez. I'm doubling the number of jurors for Ms. Gardner's case in anticipation that there will be more knowledge about the case. So I also need Ms. Gardner's team to kind of think through some logistical things. For example, in Mr. Fernandez's case, we're bringing up 50 jurors morning, 50 jurors in the afternoon. I've doubled that number for Ms. Gardner's case, 100 in the morning, 100 in the afternoon. But I got to, with the other Mr. Fernandez's lawyers and team, that they wanted, and this is all kind of like food for thought that I want you all to think through for your positions at the final pretrial, meaning that Mr. Fernandez's team wanted to get to 70 questioning jurors. I need you all to get to a number that you believe, both sides, right? That this is the number that we want to be able to substantively question. Ms. Giannaco, how many jurors does this courtroom comfortably seat? How many jurors can we get into the pews? 100. So if you wanted, and you all have not been a part of the discussions, that's why I'm bringing it up now, okay? Our thought process in the Fernandez case has been get to whatever this magic number is, okay? And then we have that number of jurors fill out the questionnaires. You all will have the time to do whatever background information / thought process into your questioning. And from the questionnaires, the parties may glean that this person should not sit, that they're ripe for a cause challenge. I don't think that we should necessarily take up the seat nor the time having that person sit through, a substantive analysis, and we can go through an excusal period based on questionnaires. That both sides, maybe you agree. And I did share the updated questionnaire with the Gardner team, didn't I, or no?
I don't believe you did, Your Honor.
Okay, I'll send that out. I would ask Ms. Wilk I'm going to ask her to send that to you. It'll have Mr. Fernandez's, but I haven't made the changes on it.
Sure.
And so I want you all also to look at the questionnaire from Mr. Fernandez. If there's anything else that you want on there, if you would let me know. At this point in time, actually, I can give you a copy before you go. Ms. Russell, Ms. Hathaway, do y'all have a copy of it?
So guys, because they were talking about the jury, like the jury stuff, and we kind of heard pieces of that from Fernandez, Mario's thing from last week. What I am going to do is I am going to pull us forward so we can get to talking about the actual motions and things that that's more important to us at this point in time for our purposes. Let me see. I had to, I'm gonna pull us forward so we can kind of get to the motions and the arguments and things of that nature. So we'll do that because I don't want to hear about the juries again, about, Okay, so here we go. Let me pull us up there. Okay, so he gonna be on Zoom. Okay, okay, here we go. $37.19. I just want to make sure I get this. Okay, here we go. This should get us into the meat and potatoes of this.
Stage is ready.
Yes, Your Honor. The defense, on behalf of Mr. Fernandez, Jesse Dreiser, and I represent Mr. Fernandez, along with Mr. Hill is present, Ms. Day is present, and my client, Mr. Fernandez, is sitting right behind me.
And I think I saw Mr. Tassoni on Zoom.
Okay.
Good morning, Your Honor.
Good morning.
Good morning, Mr. Tassoni.
All right.
Little housekeeping, the defense would make an oral motion to have the court order juror anonymity and protection.
And does the state join in that motion as well?
State joined, Your Honor.
Okay. So in the upcoming jury selection, the court, obviously by previous order, has determined that 2 phases is necessary. The court will enter an order on juror anonymity and also protection in pursuant to Rule 2.420. Taking that rule completely to heart, the prospective jurors that are excused will only be, the court records will only be confidential for the time period that is necessary in order to select the jury. And then once that jury is seated, their information will become available to the public records laws. Then the seated jury and the alternate jurors will also be protected, obviously, for the end of the trial proceedings. And so I'm entering that order today, so I'd ask the clerk's office to file that. I believe that we've talked about, at least at sidebar, some administrative matters, and so I'm ready to go on to substance if you all are.
State's ready.
Defense is ready.
There are a couple of motions that have been unresolved and that, you know, I've been helped because the docket is deep. So I'm going to bring up some blasts from the past. There was a defendant's second motion for bill of particulars, and I think that...
Yeah, that's going to be a star feature of today's issue.
And then there was, on March 30th, 2026, docket line 570, there was a defendant's motion to suppress the cell phone records.
That one the defense withdraws.
Okay. Thank you. I know that we have mentioned it on prior dates, but there was no resolution by the court on docket line 597, filed on April 17, 2026, the defendant's motion to adopt Gardner's motion to exclude minor child.
I believe that was resolved by way of a stipulation of BB.
We filed a written stipulation.
Okay. Thank you. Could you all find that for me? Do you know what docket line the stipulation's on?
Yes, Your Honor, one moment.
Abandon that one.
Judge Weaver, I believe it's moot because of the state's notice of which counts we're proceeding on. I did provide Mr. Dreiser with a written stipulation regarding BB and the admission of a video. I'm just waiting for them to sign it, and then we will file it.
And it wasn't not signed for
Right.
any other reason than I thought I signed it already.
Oh, okay.
So.
Well, I'll just put, it's fine. I'll just put by stipulation of the parties, moot.
Yes.
Okay. All right, and now I think that based on that, going back to the docket line 516, I think that we're now up to date on what's pending. So which one do you all want to take up first?
I think Mr. Mizrahi and I agree we'll take up the defendant's first motion in limine to prevent the introduction of hearsay and impermissible testimony, if that's okay with the court.
Yes. Okay, I'm ready.
So, Your Honor, just let me sort of outline what this motion is as well as the other motion, because they're very much blended, okay? So there's two anticipated statements that we believe the state is going to try to get in. For the purposes of, before I get to my argument on the very first motion, they're both statements that we believe are covered by the marital privilege. The state's theory of why they should come in is the marital privilege doesn't apply, at least to the state's first motion in limine. I'm not sure their theory on the second, but it comes in on the state's first motion in limine under a co-conspirator statement. So the reason I bring this up is, number one, many of the marital privilege arguments will go to motion in limine number one, as well as motion in limine number two. In addition, it's our argument, and I do think the state actually agrees with this, that if you find that the statement between, in defense motion in limine number one is marital, we don't have to go to whether it's a co-conspirator statement. It wouldn't come in because it would be marital. So I bring that, there could be some efficiency here to sort of decide whether we need to go into the second argument. If you find it's marital, there's no conspiracy argument to be made, and it would save quite a bit of argument as to those bill of particulars, as well as the complexity of conspiracy law. So I'll let you decide where you're at as terms of marital privilege. But marital privilege in the state of Florida under 9504, it reads, a spouse has a privilege during and after the marital relationship to refuse to disclose and to prevent another from disclosing communications which were intended to be made in confidence between the spouses while they were husband and wife. The privilege may be claimed by either spouse or by the guardian or conservator of a spouse. The authority of a spouse or a guardian or conservator of a spouse to claim the privilege is presumed in the absence or contrary of evidence. Then the statute goes on to very clearly say that there is no privilege under this section under A, B, and C. But I'm going to focus your attention on B because that's what the state is attempting to break the marital privilege. And it says, in a criminal proceeding in which one spouse is charged with a crime committed at any time against the person or property of the other spouse, or, and what the state's relying on, the person or property of either child of either. And that's what the court has to specifically note in this argument. If there's any argument that it was anticipated that by these statements that the state's trying to elicit, that they even would go to the fact that child abuse was anticipated in this case, it would be against BB, who is a child of Jared Bridegan and Kirsten Bridegan. BB is not a child of Mario Fernandez. BB is not a child of Shanna Gardner. The statute is explicitly clear as to that point. I will read to you directly from Earnhardt as the abrogation of child abuse statute, as well as the concept of the statutory construction that it has to be a child of either, is addressed. In addition, there is no marital privilege if the crime charged is against the child of either spouse. Policy reasons require that the privilege not be recognized. The policy is reflected in section 39204, which I will represent to you as the abrogation of child abuse, of Florida statutes, which denies the marital privilege in litigation arising out of child abuse cases if the crime has been committed by one spouse against the other spouse or the other spouse or a child of one of the spouses. There is no benefit to the marital relations by suppressing the testimony. There is a public policy to not allowing, in Florida, as you know, one spouse can raise the privilege against the other spouse. There's a public policy reason that you can't prevent your own husband or wife from not talking about the abuse of the children of the marriage. There's no public policy that would allow, and there is not a single case that I can find in the state of Florida that addresses the marital privilege being broken because it's a child of another. And if we look to the Williams case, do you have a copy of that, Your Honor?
Give me one moment. I do. Okay. I'm ready.
On page 2, we find that Ms. Williams' statement regarding appellate's street name was not protected by the husband-wife privilege
because that information was known generally in the community. However, considering the record before us, we must conclude that the trial court erroneously permitted Ms. Williams to testify about appellant's statement that he needed money to pay his attorney. A communication between a husband and wife is presumed confidential unless there is evidence to the contrary. At trial, neither appellant nor his wife testified whether they meant their communication to be private or public. Likewise, there was no testimony that the statement was made in the presence of a third party or that the appellant instructed his wife to disclose this information to another person. Without this information, it is impossible to determine whether that privilege had been waived. As such, the state did not overcome the presumption that the statement is covered by the husband-wife privilege. Therefore, it was error for the trial court to admit Ms. Williams' statements over defense counsel's objections. And the reason that's so important is, I suppose the state could make an argument that the statement that they're trying to elicit, which has never been clearly outlined, but we assumed that Shanna Gardner tells her friend, Kim Jensen, about a conversation that Mario had with his wife, Shanna Gardner. So it's what Mario Fernandez supposedly said to his wife, not in the presence of a third party, no evidence that was instructed to be shared, in confidence with his wife, and then his wife tells the friend. And in Florida, of course, one party can elicit the privilege, and unless the state has evidence, independent evidence, to prove that Mr. Fernandez did not intend for that statement to be confidential, it's a marital statement. Of course, the state also cites the Hill case. And do you have a copy of that, Your Honor?
I do.
Okay. So the brief facts of the Hill case are that a husband and wife have a conversation at some point about whether or not there was any issues regarding the functionality of the cruise control on the car. And in this particular case, the wife, in an extreme tragic, left an appointment. She had her child in the car, and she had a neighbor's child in the car. And her child was killed. And in the Hill case, they go on to say that the abrogation of child abuse statute did apply. And of course, in that particular case, the child of the husband and wife was killed. And what I would point out specifically is that on page 4, when they go through the privilege, they specifically say in B, in a criminal proceeding in which one spouse is charged with a crime committed against the other person or property of the other spouse or the person or property of the child of either, emphasis added. So this case, clearly the court had the right because they believe that a child of theirs passed. And then the court goes on to a whole nother analysis of the psycho-patient privilege. The state in this case has provided State v. Jett, which is the psycho-patient privilege, and it's just inapplicable. Every privilege in the state of Florida has its own statutory construction. There are exceptions for the attorney-client privilege, there are exceptions for the psycho-patient privilege, and there are exceptions for the marital privilege. And there are dozens, if not hundreds, of cases that talk about how the marital privilege is one of, if not the most, protected privileges of all for many public policy reasons. In fact, they all say that if the court were to deny a marital privilege, you can take a writ of cert prior to trial, because in fact, you cannot stuff the cat back into the bag. That's what the case law says. It is so imperative that the communications between a husband and wife are never breached unless there is clear authority from the court that it be breached, that you can take a pretrial writ of cert. I did find, and I sent this morning, the Schwartz v. State of Florida case. Do you have that, Your Honor?
I do.
I went and I spent more time than I'd care to admit on my case law research trying to find one case where the abrogation of child abuse was used and it was not a child of either. I didn't think I'd find one because it's clear in the statutory construction that it says a child of either. But I went as far as I could to find one. And I found a 2025 case, Schwartz v. Florida, 413 Southern 3rd. And in this particular case, it was a husband and wife who presumably had some communications, and then there was a Ring doorbell or some kind of surveillance. And the court ruled that surveillance or observations between a husband and wife are not privileged. And I don't dispute that. I've known that for years. It's only the communications. And in this case, the child that was abused was not a child of the husband and wife. It was a niece of the husband. But in looking to try to find a case, what I found instructive was if you go to the facts and you go to page 5 of 7, Your Honor, where the court rules in favor of the state and says it's not privileged. It was an observation, it was a Ring doorbell camera, and that matter is not privileged. But if you go to the first paragraph at the top, where I do think is instructive, is the last sentence. The trial court disagreed, ruling the footage could come into evidence, but directing the state to present a, quote, truncated, end quote, version to exclude any protected marital communications. If the state's premise is true, and that it can be a child or a niece or a child of anybody, any other couple, they would have never wrote that. They would have said it was an abrogation of child support. This niece was clearly accused of child abuse. It was child molestation. And the court ruled that the marital privilege still remained intact and instructed the state to have a truncated version to not invade the marital privilege. So although I don't believe this case is directly on point, it does give us just instruction that when there's a child abuse case and there's a niece, not a child, the marital privilege is still, in fact, intact. I also would, if you look to the actual statement that the state is trying to elicit, Your Honor, let me find that. Something to the effect of, did Shanna ever tell you that she told Mario that she wanted him to act upon that promise? Jensen, Mario told her, if you don't, I can't remember exactly when the conversation was, but he told her, if you don't want this to happen, you'd better tell me now. And she said, do not. I choose you. I don't want this. I choose you. Ms. Rahi, she told you that she told him that? Yes. Ms. Rahi, but you don't know when that was in this whole timeline? Jensen, I think it was in Hawaii the last time they went, but she said, I don't want this. I don't want any part of this. I don't want you to do anything. And I'm going to read from more of that if we get into the conspiracy argument, because she later goes on to say, I really don't know when it was. It could have been in another trip. But for the purposes of that statement that they're trying to get in, what part of that statement, given that there's absolutely no agreement in there, would give anyone rise that that would lead to child abuse? Ms. Jensen never clarifies, and she's testified before this court, and she's spoken in front of the grand jury, and she's spoken at bond hearings. She never clarifies what that is. She doesn't say whether it's to beat him up, whether it's to murder him, whether it's to make sure that he lives a rotten life. There is no ever explanation, and even more so, the conversation she reports is that Shanna Gardner says, no, don't do that. I don't want that to happen. I choose you. So before we even, I'm not conceding that it is the abrogation of child abuse statute even applies to this case, because it's not foreseeable from that particular statement that this was going to lead to child abuse. If the court's not persuaded by that, BB, the child who, and I don't mean to say this disrespectfully, supposedly was abused in this case, the state dropped the child abuse count. The child was very young. We've deposed all the witnesses. I don't agree that BB had any actual child abuse physically or mentally from that. But regardless, BB, and more importantly, BB is not a child of Mario Fernandez and Shanna Gardner, and therefore there is no vehicle in which the state can get that statement in. I would think that it would be most efficient for me to move to my second motion in limine
Okay.
and then argue the same marital privilege and then see where you're at after the state argues, and then we can go back to whether, if you say, I don't believe it is marital, if that's the conclusion you come to, then we would argue whether it's a co-conspirator statement or not.
Okay.
Okay?
You can move on.
All right. My second motion in limine is in regard to a motion in limine to prevent the introduction of impermissible testimony, which is statements that AB, who is a child of Shanna Gardner and Jared Bridegan, says in a recorded interview when she is interviewed by a police department, I think in North Carolina. They ask her about some new information. And this is what she says, Judge. Ms. Stifler has told me she's going to introduce the actual 4-minute clip on a CD.
She's Ms. Stifler.
Do you want to put the video in?
I apologize, Your Honor. I thought we were handling the first one. I provided a video clip to Mr. Hathaway upon stipulation, and I think no objection from defense. It's a roughly 3.5-minute video of a police interview conducted of AB by New Hanover Police Department in North Carolina. Timestamp 25 minutes, 25 seconds to 29 minutes.
And
So this is being published on the media. Do you want to?
How I would present my argument is I transcribed it, not through a transcription agency, but Ms. Day transcribed it word for word. I've shown it to Ms. Stifler. I think she agrees that it's accurate. We can still put it in, but I was just going to read exactly what it says.
Okay. Is that acceptable to the state?
Yes.
Okay.
So just to give some context, Abby's in a child protective type room. A detective's in the room. She's on a couch, and Abby says, in response to some question like, "Is there anything that you would like to tell me?" Some generic question. At my house in Florida, it was a 2-story house, and I was on the 2nd floor, and I had a master bedroom, so I covered like the whole house pretty much. And you could hear what they would talk about. And they would just be like, quote, "Oh, he'd be better off dead," or something like that. The detective asked who was they, and Abby said, Shanna and Mario. When asked when she heard these jokes, Abby said, it was like for a long period of time. So they did it like months. It was kind of off and on when they would talk about it, but they did it like before he died, and then they didn't talk about it that much during like the 2 months after, but after they kind of talked about it. When asked what else Shanna and Mario said, Abby said, they just said like, he's a horrible person. Like, I wouldn't feel bad if he like died. Like, he has a right to die. He doesn't deserve to be in this world. That's what I remember. The detective asked if they ever talked face to face with Abby about stuff like this, and she said no. Your Honor.
Judge, the reason I wanted the court to watch it, I think there's just the context and how she says things matters a little bit. So just to add, at least from my notes.
Well, you can play it. I mean.
I don't have an objection to it being played. I don't have an objection to the court taking it into chambers and listening to it.
That's fine with the state.
I have no objection. My notes, I believe, are accurate, but admit it, play it in chambers. It doesn't change my
If you want to play it, I'm just pointing out, last time AB was an issue, you asked for non-publish of the video. I'm happy to hear it if you want and see it, but if it's published on the card, they would have to kill the videos.
It's a CPT interview, so I do believe there are some protections for public records exemptions, which is why I wanted to provide a copy to the court to review.
Do you want me to do it in chambers? I can. Okay.
Yes, ma'am.
Mr. Dreiser said you were going to play it, so I was just pointing it out. Okay.
You want to do that in chambers now or later?
I can go back now. And
It's only 4 minutes.
I think we could do it later. Let's just get through the arguments and then the court can.
Sure
that's
enough.
my thought process.
So, Judge, again, reading directly from Earhart's, however, when there is a reasonable expectation of privacy, and if the spouses intended their communications that their communications are privileged, the privilege applies despite the fact that communications are overheard. If an unknown third person listens through a closed door, and when it is not reasonably apparent to either the husband or the wife that the third party is present, the privilege is not destroyed. When you watch the video and when you hear the statements that I made, AB is clearly talking about being in her master bedroom upstairs. She has like what she describes as a very big master bedroom. And Mario, Mr. Fernandez, and Ms. Gardner are downstairs. And then luckily for us, the defendant specifically asks, did they ever speak with you face to face about stuff like that? And she says no. So again, you go back to the case of Williams, where it talks about privileges, it talks about reasonable expectations of privacy, and it instructs the court that the state has to prove by independent evidence that Mario, Mr. Fernandez, and Ms. Gardner would not have intended that conversation to be confidential. And there is no way from the clip that you're going to listen to in chambers that there is proof that it was done in front of her or they knew, and she starts out the whole premise with, I would be upstairs in my room and they would be downstairs. It's not even a door, as example like Earhart uses. It's a whole floor of a house. So again, I do not believe the marital privilege is broken. I do not believe AB should be able to testify to conversations that you have no independent evidence were meant to not be privileged between a husband and a wife. And we would ask for you to exclude all of the statements that AB allegedly heard by eavesdropping between a conversation between a husband and a wife. If I just have one moment, I think I can turn it over as to those two issues to the state.
Okay.
Thank you, Woody, for your help.
All right. Thank you.
Are you done? Say, give him a minute.
Oh, okay.
I'm sorry. Yes, Your Honor. I'll turn it over to the state.
Thank you. Mr. Mizrahi?
Thank you, Your Honor. May it please the court. Defense counsel is erroneously stating the state's theory on this, and I'm going to take the court step by step about why there is a clear piercing of the husband-wife privilege in this case. The first idea is that Mr. Dreiser indicates that we're only going on the theory of BB being in the vehicle when her father was shot, which the state had charged as child abuse, and that certainly is one theory. But frankly, the stronger theory the state is going on is that the motive behind this killing, and we will present this with witness after witness after witness, that the motive behind this killing was to eliminate Jared Bridegan's custody of his two children, the children of Shanna Gardner. That is why this murder was committed. And obviously, this is a hearsay statement between husband and wife, one of which their children was the goal of why the victim was eliminated. The child abuse statute under 827.03, which I know the court is familiar with, defines child abuse as an intentional act that could reasonably be expected to result in physical or mental injury to a child. There is no other interpretation of that statute than the murdering of the father of two minor children would not reasonably be expected to cause mental injury to the child. It is just that simple. And if that is true, the court doesn't need to make any more findings about whether or not the husband-wife privilege is pierced. But additionally, the state provided, and I appreciate Mr. Dreiser providing the court with the case law, but he neglected to mention the Supreme Court case of Florida that the state provided, Your Honor, State v. Jet, 626 Southern 2nd, 691 is a 1993 case that specifically and unequivocally states, we answer the rephrased question, which is whether Chapter 39, proceedings relating to children, abrogates the privileged communications involving child abuse, whether it only applies if it's one of the caregivers. And it says, we answer, I'll read the question, the certified question, and then the answer. Does Florida statutes 90, and it gives the year, waive the psychotherapist client privilege only as to proceedings brought under the Florida child abuse or neglect statutes? Under 39 and 827, we have jurisdiction. We answer the rephrased question in the negative. We find that the waiver of the privilege in this context reaches to any proceeding involving an action or offense that meets the statutory definition of child abuse or neglect, whether or not the child abuse or neglect is a necessary element of that action or offense. Chapter 39.204 does not in any way, shape, or form indicate it has to be a child of one of the others. It doesn't say that. It says the abrogation of privileged communications relates to, and I'll read it, the exclusion of confidential communications shall not apply to any communication involving the perpetrator or alleged perpetrator in any situation. Those are restricted to the children of the perpetrators. In any situation involving known or suspected child abuse, abandonment, or neglect. So, Chapter 39, in conjunction with the husband-wife privilege under Chapter 90, clearly sets an exception to cases involving suspected child abuse. And that goes as well to the second motion in limine with regard to AB and the potential eavesdropping. The only comment I would make for that is the state would request a proffer of AB with regard to the issue of eavesdropping if the court does not find what the state is arguing, the husband-wife privilege does not apply to any communications between the co-defendants about the murder of Jared Bridegan, since the goal of that murder was to eliminate the child custody of the victim. And then we would like just, if the court didn't find that, we'd want to proffer that. I just mentioned that. So, but
At what point in time?
When we present it, it wouldn't be an opening or anything like that. I would also, just interestingly enough, the court's worried about our ability to prove child abuse. I would point the court to the Hill case that the defense mentioned, which is Hill v. State, and it's 846 Southern 2nd, 1208 is 2003 50 CA case. And the court was a little bit troubled by the concept that, well, this child abuse, or in this particular case it was a child neglect, seems a little far-fetched. I want to read to Your Honor what the court said. It says, although we have found no case in which the defendant has been convicted of the crime of child neglect because of his or her reckless driving of the vehicle which resulted in injury to a child, if the defendant's reckless driving is shown to be sufficiently gross, there is no reason the charge could not be proven in theory, because of the clear statutory language in both 39.204 and section 827.03, which is the child abuse statute. We agree with the trial court that the psychotherapist patient privilege does not exist in this case as to any communications relevant to the child neglect. And so we have statements about he doesn't deserve to live, I'm going to kill him, all relate to the elimination of the parent of these two children. Elimination of a custodial parent of a minor child can reasonably be expected to result in the mental injury to those children. We don't have to prove the child abuse according to very clear case law. It doesn't have to be charged, nor do we have to prove the child abuse beyond a reasonable doubt. But the statements have to relate to suspected. Remember, Chapter 39 says suspected child abuse or neglect. And so for those reasons, the husband-wife privilege does not apply to statements made by co-conspirators about the murder of Jared Bridegan.
So what is the state's position as to the first motion in limine to Ms. Jensen?
Well,
And Mr. Dreiser's argument that those statements, to that point, like they're vague, they don't say one way or another.
he's referring to one statement. I think I understand what the court's question is. The state is not just introducing that statement. We will be introducing a series of statements that set forth the concept that Shanna Gardner was trying to hire someone, find someone, ask someone to kill her husband because of child custody issues. I anticipate that the witness will testify to that. Although she will qualify it by saying, at least if she's allowed to say what Shanna Gardner was thinking, which is the subject to another motion in limine, I do believe that Jensen can testify as to what she believed and what she thought. She thought these were all just jokes. But the evidence is an offer was made by Shanna Gardner saying, can you find someone to help me? Jensen accepted that offer by seeking out other people to kill Jared Bridegan. And then the conversation was all about the custody of the children. The elimination of Jared Bridegan was not for any other reason other than the fact she couldn't tolerate this man supervising her children. Her children would go to him, they had joint custody, so every week they'd be gone for 6 or 7 days, and they would have 1 day of visitation, and they would go back and forth and back and forth. We are going to be able to establish that and a timeline continuum that was never broken, under which Shanna Gardner told Kim Jensen, I can't stand my ex-husband. I don't want him to have custody of my children anymore. That's the whole basis of the whole child custody issues in the St. Johns County case, is it was all about child custody. Mario came to the picture, and Fernandez was going to solve this child custody issue. And even Jensen will testify to that he said he could solve the child custody issue. And then Shanna Gardner repeatedly told Kim Jensen multiple different situations under which Mario indicated to Shanna Gardner how Mario Fernandez was going to solve the Jared Bridegan problem. That he could almost touch him. He had people that were out looking for him. He knew people that could do things and help her. They're all relatively vague statements, but remember, they don't have to be direct. If the point is to take care of the child custody issue, and he says, I'm going to solve that, and then as Mr. Dreiser indicates in the last statement, which is a week before Jared Bridegan is murdered because it's during the Hawaii trip, that Kim Jensen says, at that time, Mario Fernandez was unequivocal saying, I am finally going to make this happen. You have to tell me not to. And then Jensen's testimony is that Shanna Gardner says, Mario told me he was going to kill the victim, take care of it, get rid of him, whatever language you want to use, and I told him not to. But that is for the weight of the jury to decide whether or not those statements were really made. The statement from Mario to Shanna Gardner should be pierced because he says, I want to kill the victim, and it's for child custody. Does that answer the court's question? We have years of these statements.
Okay, but what's been identified for the court to rule on is very short, it's succinct, and so the defense is not bringing objection to what Mr. Mizrahi is outlining?
Yeah, I'm bringing enormous amount of objection. We now have circulated into the statement of bill of particulars, and it is quite frankly unbelievable to me that the state is now relying on the years of Shanna Gardner's and Kim Jensen's messaging to each other in Mr. Fernandez's case. It'll take me a minute to get prepared to argue how absurd that is.
Okay, well, why don't I take a break and I'm going to look at AB's video. But
I'm ready now.
I can't rule on something that's like what I have sitting before me is not even 2 pages.
Well, certainly we can submit the sworn testimony of Kim Jensen, but until,
Right, but what I'm saying is, so what was before me is a statement Mr. Dreiser has made a succinct argument saying, and that's why I asked the question, is because the state's argument that Hill applies to the statements of Jensen, saying that the statements go to that. The substance of this statement, Mr. Dreiser has argued, vague, doesn't go to any sort of child abuse, and then now the state is bringing in other statements that aren't being objected to. I was just trying to clarify.
Maybe I didn't point. The statement to pierce the husband-wife privilege doesn't have to, in the statement itself, talk about an act of child abuse or neglect. The statement, they said the Schwartz case had to do with cruise control. So the statement itself doesn't have anything necessarily to do with the underlying crime. It's our duty and our responsibility, whatever our burden, to be able to establish that that was the underlying purpose of the statement. So the statement, I'm going to take care of Jared, doesn't say anything about the children. We are going to establish via other evidence, specifically the defendant's own words, that he was going to eliminate the victim specifically to eliminate his child custody rights over the children. This was all about child custody. So we have.
And so what you were proffering to the court would not be statements related to the marital privilege. You're saying that those statements are kind of outside of what is being objected to within this motion.
For us to be able to establish that this was not marital privilege, we will present other evidence, like the defendant's own words after the fact to a third party saying, I did this for child custody reasons.
Where is that statement in discovery?
Excuse me.
Okay.
I'm not arguing right now. I'm paraphrasing. Obviously, I'm paraphrasing. But we do have evidence of that.
Well, I'm gonna take a break. Okay. Let me see AB's video and you all talk. Okay. Court's in recess.
Doesn't.
AB's first. Mr. Fernandez is back. Did you all have a chance to talk?
Briefly.
Okay. All right, so I did review the video that was submitted. My impression for purposes of the ruling is that the AB's first statement places her where both sides, I think, maybe agree, but then there's a second portion where the detective circles back and then she makes the list of statements related to horrible person, all of those things. There isn't a lot of clarity that I was able to glean from either one of those segments of statements. She also, in the first set of statements where initially she places herself upstairs, I don't think that can make any findings related to that unless it's clarified. And so I think the state's request to proffer, unless it's clarified in a deposition, I don't think that I can make any sort of ruling based on that is Mr. Fernandez and Ms. Gardner's expectation of privacy.
It's the state's burden.
No, I agree. And so they're asking to proffer. What came to my mind is it clarified some other place besides this video?
Well, it wasn't, because at the time that AB gave her deposition, these statements had not been disclosed. They hadn't even been made yet. They were made a year, maybe two later. And additionally, we've always, even if I was deposing AB, this is the first we've ever heard of this theory. So the child abuse count was always BB. They've dismissed it. I think that's irrelevant. But there's never been an allegation that the children that we should be worrying about their physical or mental health was LB or AB. Never until this morning What have we ever asked a single question? We've never been provided a mental health record of LB or AB. We've never been provided a physical medical record of AB or LB. It never would have come up in deposition.
Okay. So how are we going to rectify the problem?
Well, I think regardless of whether this is eavesdropping or not, it's admissible. I think the statement is pierced because they're talking about doesn't deserve to live. And we're going to be able to circle back by other evidence. And the whole concept of their statements about their discussions about Jared Bridegan centered on the custody of the children. That's what this was all about. I think the husband and wife privilege has been pierced regardless of whether this is an eavesdropping or they have an expectation of privacy or not. I think the court can rule about it. I mentioned only the proffer as the backup, which the court, I mean, we have no problem waiting until we put her on the stand to clarify this.
I think that it's too big of an issue to wait. Number one, it's been brought in a motion in limine. Number two, so if the court follows the state's theory/analysis, okay, what is to stop the state from asserting this sort of theory / in any murder case where the victim has a child and then say, well, all privileges fall away because it would assert mental injury or mental child abuse against the deceased victim's child?
And that's a great question, and the answer is equally as great, because this murder was about the kids. If there's not evidence, if one defendant, a gang member, shoots another gang member out there on the streets, and there's no evidence that the shooting had anything to do with the child custody or the custody of that person's child, then husband-wife privilege would apply. Going back to the whole concept of a public policy, Your Honor, there is no public policy for husbands and wives to discuss the murder of one of their children's father. There is no public policy. Now, we got a little, I mean, it exists, the statute exists. Many other jurisdictions have a crime fraud exception to husband-wife privilege. The state of Florida does not, but it does have this abrogation. And this abrogation is, if this act is about children, then it's pierced. The whole concept of this murder is about eliminating his child custody, eliminating the father of these people's children, and that is an act that reasonably could lead to their mental injury. So it's not in every case. There is no slippery slope. How often do we have murders where the purpose and motive of the murder is to eliminate the child custody? How many murders do we have where we even know they have children? It has nothing to do with the children.
Is there any case that would stand for that proposition?
What?
Ever? I mean, this is not a new or novel motive, right? So
it is a unique motive, and it's very, very rare to have husband-wife privileges that have to do with the murder of the children. I think that's incredibly unique. It's a very rare set of circumstances. I think the case that I cited is the clearest example of where the courts are going to fall on this.
You said Hill.
Which is Hill, because it has to do with some, I mean, it's a reckless driving that they've alleged a child neglect to it.
But there's actual, within, it's not a motive argument, it's actual in the facts that the child was, in fact, injured. To me, that's an easier question than what you're asking this court to do.
Well, we have a child that has been injured as a result of this case, an act that reasonably could lead to their injury, because again, I think that the 39 pierces husband-wife privilege, regardless of whether it's their children or not. It doesn't matter whose kids it is. So we have two theories the court can rely upon. One is that BB was in that car with bullets flying by her, which is exactly like Hill, that the person's in the car with crashes happening right now, and that act of child neglect is pierced because of that. Now, I would concede that the discussions about the murder, which is what we're trying to introduce, don't relate to BB being in the vehicle. I concede that aspect. But we do have evidence that this was done, although not expressly made, this was done during a known date night, which the court is aware of, in which BB would always be in the car. One of the children would be in the car, and the murder took place when they knew the child was in the car. So we have that. But the express...
Aren't those facts kind of outside of my universe right now? I know it's part of your argument, but it's kind of...
Well, I mean, the courts have talked about we have a trial before the trial? I mean, I don't know how else to do
No,
that.
what I'm saying is,
These are matters of the record. The court has heard plenty of sworn testimony in this case, and I'm not speaking outside of that.
right, but the court is also not an investigator. Like, I can't comb through like all the hearings that we've had. It has to be kind of a part of the succinct hearing that I'm having right now. I can't go digging for the state when the state has the burden in its argument at this point. Like, if you want me to consider it, I think it has to be the universe of this hearing. I'm not an investigator.
Well, then the state would be introducing and asking the court to take judicial notice of all the sworn testimony in this case. We also will be filing all the depositions in the case. And we would ask the court to do that in lieu of live testimony, because we're going to have a trial in 2 weeks. I know that's a large burden on the court, but these are typically, when we're dealing with motion in limines, which is what the defense has filed, the facts are generally agreed upon, and that this is more of a legal issue.
Right.
I don't think the defense is disputing the fact that the state is going to establish that the motive for this killing was the child custody. We have evidence of that. That will be presented in the trial. And so the question then becomes, is the motive, I think the court has to answer one very simple question. That simple question is the motive behind a murder, if that motive is child custody of minor children, does the murder of that person pierce husband-wife privilege? And it's just that simple. And that's the legal issue I think the court needs to find. And if that is true, then of course, if we go to trial, the state's unable to do that, we undertake that in our peril. But we are going to be able to establish the motive behind this killing was child custody, and therefore the defendant's discussions about eliminating the victim was done for the purpose of child custody, which pierces under Chapter 39 and frankly under 507, I think it is. Thank you.
Say thank you.
I said thank you.
Okay.
It doesn't. 39, the abrogation of child abuse, does not pierce the marital privilege. In JET, it pierces the psycho-patient theory, psycho-patient therapist theory. The psychotherapist is never going to have the child of that therapist who is being abused. So they rely on that statute. Mr. Mizrahi wants to ignore that you go back to the marital privilege statute, which specifically says a child of either. So now the BB, which now they've circled to a new theory that now it is BB, although that's the first I've heard of it. And now they're suggesting that it's because LB or AB could reasonably have an issue that they've never disclosed to us before, that's how it breaks the privilege, because that is a child of theirs. And then Mr. Mizrahi just came in and just told you facts that simply are not the case. He told you just a moment ago that the proffered evidence is that Kim Jensen would tell you it was a week ago. Let me tell you what Kim Jensen would tell you. They had different parenting styles. It was obviously, things were not perfect. And so they would have.
Where are you reading from?
I'm reading from.
I can submit the testimony from Kim Jensen in the hearing, as well as Kim Jensen in the unsealed grand jury proceedings, for your honor.
I bit my tongue, and Mr. Mizrahi did remind me during the break that we shouldn't interrupt each other, and yet I've just now been interrupted.
I was responding to the court's questions.
I had it in front of me. I think the court was asking me what I was reading
Right.
from.
Well, if you're reading it, here you go.
You may continue, Mr. Dreiser.
So in relation on page 82 to the very dialogue that we put in our defense motion in limine number 1, they go on to ask her about when all of this happened. Now, in the very statement itself, she says, I don't know. He told her, if you don't want this to happen, I'm sorry, she starts with Mario told her, I can't remember exactly when the conversation was. Then, in their grand jury, they're pushing her, you know when it was. It was in Hawaii, and this is what she says, bottom of page 82. They had different parenting styles. It was obviously, things were not perfect. And so they would evaluate whether or not they were going to stay married. And so I don't recall if it was that particular trip or, another one. I just I know that it happened, that conversation happened on a Hawaii trip. Which one, I wasn't sure. And the evidence in this case is they went to Hawaii yearly. So the idea that it's the week before, she says in 2 different spots. And in all of her testimony, she doesn't know when that statement was made. So they're putting facts and evidence today in this quasi-proffer that they want you to believe these things are true. That it is apparent that this is over child custody, because if you look to the divorce in St. Johns County, Mr. Mizrahi told you it would be apparent that they were having child custody fighting issues. No, it's not. There is no motions regarding child custody post-dissolution. And I'll explain with the exception. In this case, there is a marital agreement, consent order.
Mute yourself.
Mute, please.
Mr. Mizrahi. Your microphone.
So they come to a consent order, which means that there was no trial, and the parties agreed to 50-50 time sharing. Then for a short period of time, Jared Bridegan moved to, I believe, Utah, and there was then a consent order regarding what the time sharing should be. Then when he moved back, there was a consent order that they have equal time sharing. And then there was a motion about what what school the children should go to, a medical device motion, every single one which resulted in a consent order being entered. These folks didn't go to court one time to resolve their initial divorce, which was agreed child custody, and any other subsequently post. There is no motions that the court will be presented with that they were fighting that one person should have more time than the other, that one parent was unfit, one parent's time sharing should be eliminated because of drugs, abuse, nothing. That's what a typical family law, acrimonious post-dissolution is. This parent's a drunk, this parent's a drug addict, this parent can't fundamentally co-parent, is a parent alienation, all the things that you can imagine, they don't exist in this case. So what he just told you is not what the record reflects. We've agreed on what evidence is going to come into this case, and I have in my exhibits the marital consent final judgment, as well as all of the motions and all of the consent orders to show the jury that, in fact, they want the story to be that. The media wanted the story to be that. That's not what the record reflects in this case. And in fact, my recollection is when I asked Detective Johns, the lead detective, if he had ever even read any of the pleadings in the family law case, my recollection is that he said he had not. So now they want you to adopt this idea that they have a new theory of how they can get in, and I'm going to go right into the co-conspirator statement, Judge. You asked me what happened to our defendant's second motion for bill of particulars, okay? We had a hearing on it, as you may recall.
I do not. We've had lots of hearings, Mr. Dreiser.
I understand. Well, I will tell you that the motion was filed on December 24th of 2025, and we called it up for hearing on January 22nd of 2026. I went into great detail with the court. I went through my motion, and I went through the information which was at the time a 4-count information. I pointed out to the court that all of the folks that are charged all had different date ranges.
I do remember that.
I pointed out to the court that Mario Fernandez's was from November to February. I pointed out to the court that I have no idea why it's in November. I pointed out to the court that Ms. Gardner's was totally different. I pointed out to the court that there were unindicted co-conspirators that they've always alleged. I have known about this statement from Kim Jensen to Shanna Gardner about what my client supposedly said for years. I cannot tell you, and I, as an officer of this court, tell you how many times I have addressed this with Ms. Stifler. And I will represent to you that after the day of this hearing, Ms. Stifler called me on the phone, and she said, I'm not, in the court, by the way, in the record, this will be on the record, she said that she was going to respond. She said that she would outline all of the conspiracy date ranges. She said she would, and the record will reflect exactly what she said, and if we have to rush order the transcript, I will. But I will represent to the court that Ms. Stifler called me that day, and she said, I am not trying to hide the ball. She told me on the phone, November, it's not a magic date. It's sometime when Henry Tenon suggested to us that Mario went to him and they started discussing it. And in fact, I learned for the first time that Ms. Stifler told me initially Henry Tenon supposedly said, I'm not interested. And then at some point he changed his mind and she told me there was no magic date. They just used November. And I said, okay, that makes sense. Then she told me who my co-conspirators were. And she never mentions Kim Jensen. I have asked her over and over again, because if Kim Jensen's not a co-conspirator of Mario Fernandez, then that statement can never come in. Today, there's this whole new argument as to who co-conspirators are and statements that Shanna Gardner made to Kim Jensen. I tried to address this months ago, and I was met with a phone call that said, your co-conspirators are Henry Tenon and John Biggerstaff. And there is no evidence. First of all, you should know this has never been responded to. They have never filed a formal response. And when I was told last week for the first time that they were going to try to get in this statement from Kim Jensen, I was on speakerphone with Ms. Stifler and Mr. Mizrahi. And I said, you're now trying to get this in? And Mr. Mizrahi said, co-conspirator statement. And I said, oh, after 3 years of telling me that that's not coming in. They've now decided, without filing a single response to my motion limine, or my motion for statement of bill of particulars, as to who is a co-conspirator of who. They have to tell us, independent of the statement. That's what the law says. Mr. Mizrahi provided the court with a series of cases, all of which I agree with. That is the law. Independent of the statement, they have to tell you who your co-conspirators are and when the conspiracy is. So now, Mr. Fernandez, the best I could guess from a count that has since been dropped, the conspiracy count, his conspiracy goes from November 2022 to February of 2023. So it's essentially a less than 3-month conspiracy. Now they want to come in and tell you that all of the statements that Shanna Gardner ever made to Kim Jensen should come into evidence because they're co-conspirators of one another. Those statements go back years. So what is it? Are they now just telling you and me for the first time, a week before trial, that Mr. Fernandez's conspiracy goes all the way back to 2016 or 15 before he even knew her? Which I agree is legally possible. You can join an ongoing conspiracy, but they haven't done that. The best they've ever told us is that my conspiracy is from November to February. So is it for the first time today that we're learning that he joined an ongoing conspiracy? Or do I think what their theory was all along until they've recently changed it as they prepare for trial, that there was 2 conspiracies? There was a conspiracy between Kim Jensen and Shanna Gardner, and that perhaps the object of the conspiracy was to have Mr. Bridegan killed. And then their theory was, well, once we had Henry Tenon, we have an agreement between Mario Fernandez and Henry Tenon that they want Jared Bridegan killed. That is a conspiracy. That is an agreement. It happens between November. It happens up until February. And now the object of that conspiracy. And they were fine, and it was simple, and it was clean. And their theory was certainly that those are who your co-conspirators are. That's the date range of your conspiracy. And those are the statements that we would be able to get in. But not what they're telling you today. Not what they're telling me today. And they've never filed a single thing to the contrary to tell me, when did Mario Fernandez make an agreement with Shanna Gardner to kill Jared Bridegan? It's never been disclosed. When did Mario Fernandez make an agreement with Kim Jensen that they want Jared Bridegan? When? It had to be between November and February, unless today, for the first time, the week before trial, they're going to tell me that my conspiracy goes back years, Judge. Which, if they're baiting me into a motion for a continuance, I guess that is where we're at. Because we're now talking about what could be perceived as thousands of messages between Shanna Gardner and Kim Jensen as to what their whole plan was before Mario Fernandez may have even met them.
Let me stop you. Is that what the state's doing?
Are we done with the husband and wife privilege, or are we going to
I believe that we've transitioned into the bill of particulars.
Your Honor, we abandoned the count. We're happy to provide a bill. We abandoned the conspiracy count. What are we talking about now?
Because the conspiracy, it's irrelevant. The conspiracy count is irrelevant. The law says...
Wait. I asked Mr. Mizrahi. Go ahead.
Yeah, the answer to the question is the conspiracy doesn't need to be charged.
Well, so he's asking, in the universe of facts that's going to be tried in a week, what is the state relying on? Because apparently y'all are on 2 different pages.
My job is not to sit down with them and tell them how I'm going to prove my case. My job is to make sure that the evidence that I'm going to use has been disclosed. There is not one thing I have mentioned that has not been disclosed. The court is aware of all of it. Just said, in his argument, I have known about these statements for years and years and years. Well, that's what we're relying on, the years and years and years of discovery statements, where we see that Kim Jensen and Shanna Gardner discussed how they were going to kill Jared Bridegan, and then brought in, pursuant to the defense's own acknowledgement, that 2 people can be in a conspiracy, and a 3rd person can be brought in later. We agree Mario Fernandez was not part of those original discussions because he wasn't part of the conspiracy. Shanna Gardner didn't even know who he was. But when that discussion about killing Jared Bridegan, when she married the defendant, Mario Fernandez, she brought him into the conspiracy and continued to provide updates to Kim Jensen, her other co-conspirator, about how Mario Fernandez had planned on doing this. So all of those things have been disclosed. I don't,
I agree. So what I also hear and what I'm asking the state is that Mr. Dreiser says that he's filed two motions for a bill of particulars. Neither one have been responded to except for informally. He's saying that the state has given him, I guess, an assurance that whatever is in the universe of facts would not be used against him, and therefore we've got to, I do believe, I think both of you are right in separate silos, right? Like, so yes, of course, everything is within the universe of facts, but if the defense asks through motion and the state says that they're going to respond, I think that you do have to respond.
we responded by dropping the count. We're happy to respond to the solicitation count. I don't think that's what the defense is asking. If they are, we're happy to send an email, do you want us to respond to that? Because we're happy to respond to the solicitation count. We've abandoned the conspiracy count. How are we doing a statement of particulars as to an account that we've abandoned? That doesn't, the conspiracy count has nothing to do with it. What the defense is essentially saying to you is we weren't prepared for this issue.
That is not what we're saying.
And that we were not anticipating this coming in, and the argument is that the statement of particulars should explore this.
Well, you have. I thought you did tell him, and that's why the motion in limine has been filed.
Exactly.
Okay.
I'm saying before.
Okay.
He's talking about the motion in limine from 2 years ago. I say motion, I'm sorry. The statement of particulars. That's what he's referring to, this, that he would have known about this years ago. I don't know what to tell him. We've abandoned the conspiracy count. We're happy to respond to the solicitation count, although I don't think it's going to provide him any more information than is already provided within the indictment. Shanna Gardner, the question the court has is, has husband-wife privilege been abrogated because of Chapter 39? Really doesn't matter if it's 39, because our main theory is that they're talking about their kids. So whether it's 39 or the husband-wife 90.50, a husband-wife, it has to do with their own children. Whether the discussion or a motive of murdering someone pierces them. And that's the goal of the murder, is to eliminate his custody of his children. Is that talking about suspected child abuse? And then if it is, then the next question, because that's not the only question, the next question is, does this qualify as a co-conspirator statement? And I think that very clearly is. And I started to go into that. We were able to establish a conspiracy, Shanna Gardner and Kim Jensen, where Shanna says, offer. Kim Jensen accepts that by reaching out to a third person and saying, do you know anyone that can help me with Shanna and getting rid of stupid? We've seen all that evidence. So we have that conspiracy between those two. That conspiracy never terminated. We provided the court the Epps case. The conspiracy exists until it's consummated, abandoned, or terminated. That's 354, 7th, 2nd, 441, 1978 case, First District Court of Appeals. This is well-settled law. And then the defendant, Mr. Fernandez, is brought into that conspiracy that is never consummated, abandoned, or terminated, and starts to provide information about how he's going to kill, paraphrasing, get rid of the victim in this case, again, for the purpose of eliminating his custody over their children. And those updates are then provided to Ms. Jensen. The Gardner provides those updates. This is what my husband is saying he's going to do to accomplish what we have already conspired to do. And then the statements, as already indicated, Ms. Jensen says, in her grand jury testimony that has been unsealed, as well as her testimony before this court in the hearing, is that Mario Fernandez was talked, again, that goes to the weight, not the admissibility. He was a bragger, he was joking, I didn't believe him, all that stuff goes to the weight, not the admissibility. He said on repeated occasions to Shanna, who then repeated it to me, that we were going to accomplish this. Hold on. I know the court heard everything, and everyone in the court could hear it, but we're concerned about other things. So, I've provided the court the idea of the what is necessary to get in co-conspirator hearsay, and adding people. I cite Cam v. State, which is 1983, provided the court 433 Southern 2nd 38. It's a First District Court of Appeals. That adding more people to the conspiracy doesn't change the conspiracy at all. And then more importantly, I guess to respond, and I did not provide this case, I can later, but the conspiracy, and I think the defense will acknowledge this, that the conspiracy need not be charged in order for co-conspirator hearsay to be admissible. And I think we all acknowledge that. And that's Brown v. State, 648 Southern 2nd 268, 1995 4th DCA case, as well as Richardson v. State, 338 Southern 3rd 1106, a first DCA case. I believe Your Honor may have been the prosecutor on that case, Richardson v. State. So the conspiracy doesn't need to be charged and alleged or have a statement of particulars to respond to it. The evidence, everything that I've talked about has been disclosed, and we are able to establish the conspiracies by independent evidence. And once we're able to establish a conspiracy by independent evidence, it's admissible, as long as it's a statement in furtherance of the conspiracy. Thank you.
Okay, thank you.
What they're telling you is that because they dropped the conspiracy count, they no longer have to respond because I'm not charged with a conspiracy anymore. So therefore, I then don't have to tell you what the conspiracy is, when the conspiracy was formed, who is in the conspiracy. Who in the right mind, we both agree you don't have to charge it with a conspiracy. Who would charge a conspiracy if you could just go on and leave the defense to guess? And to call our team unprepared on this issue when you're sitting in front of a motion where I literally write, Mr. Fernandez is not asking the state to provide its theory of the case or how it will prove the agreement existed, but rather what fact, act, or agreement the state alleges was made constituting the beginning of each co-defendant's charged conspiracies. To suggest that I'm just afraid or unprepared going into trial when I brought this to the court's attention, filed it, called it up for a hearing, was given representations, so much representations, you know how much work the defense has done. You know how many depositions we've taken. You know the lengths that we've gone to take depositions. We've never deposed Kim Jensen because we didn't think we had to because of the representations that were given to us that they weren't using her statements because she wasn't a co-conspirator of Mario. And what Mr. Mizrahi in all of his case law says, that in order for a co-conspirator statement to come in, Kim Jensen, the declarant, has to be a co-conspirator of the person giving the statements, has to be in the same conspiracy as the declarant or the person making the statements. So they have to prove independently that Kim Jensen is in the same conspiracy as Mario Fernandez. And now because they're telling you, well, we abandoned the count, the time doesn't matter anymore. So now, this whole time, I'm basing it off of November to February, and I guess now their theory is, well, we dropped it last minute so we can go back 5 years, without ever telling us, which we've asked for, what agreement. Mr. Mizrahi just keeps talking about things that Kim Jensen and Shanna said. And then, well, this is when have you heard one thing that Mario said to Ms. Gardner that would link him to this conspiracy? What act or statement did you hear that Mr. Mizrahi said that would link Mario Fernandez to Kim Jensen? I have to know when that was, and I have to know what it is. I don't need to know their theory, but I am entitled to that. So Ms. Gardner and Kim Jensen and all those comments and all the testimony that he says, yeah, we're aware of, sure, but it didn't apply to us. It certainly wasn't November to February. And they just want to have you say, well, they gave it all to you. In what context? years. So the first time we're learning today, they did file an information. Whether they abandoned it or not, they filed it, and they've represented to us. In so much, interestingly, Mr. Mizrahi brings up the statement of the second count, which is the solicitation charge, and he says, I'll be glad to tell you, I'll be glad to tell you. It's in the jury instructions that they provided in the draft. And it says between November of 2021 and February of 2022 is when Mr. Fernandez solicited. Now he's telling you. So in the jury instructions, they gave you a draft of this week and gave me a copy of. They're telling you, no, it could have been years. It could have been years. How? That's what I'm saying. They don't have to tell me their theory. I have been given a lot of this information. They have to tell us to get in co-conspirator statements. You can't abandon the theory that you have to prove a conspiracy existed. And in order to do that, you have to give someone the time period of the conspiracy, and you have to tell people the act or the agreement. And that's what I've been asking for, and I was wholly misrepresented as to what their theory was and who our co-conspirators were.
Okay. Taking these issues in total, from the defense perspective, which one do you think the court should resolve first?
The marital privilege, because if you find that the statements are marital, they were made in confidence, the state hasn't met their burden, Ms. Jensen's statements don't come in. If during the trial they decide that they're going to start loading all of Shanna Gardner and Kim Jensen's statements or text messages, which they haven't provided to us as an exhibit, so I don't know why they would be doing that, then we have to raise this co-conspirator hearsay issue. But if you find that it's marital, it's moot. If you find that AB's statements, that one I do agree that if you want to wait and you need more evidence from them, I mean, today is the day, but, I'll let you decide on that.
I wasn't sure. So the ask was for me to review the video. I don't think that really resolves anything related to, at least from the court's perspective. I think her statements, obviously they're short, but they also implicate a number of statements, where they were made, how they were made. I don't think any of those issues are resolved with that video. And then, Mr. Dreiser had his notes about it, but it's in two different segments on the statements. And I didn't know, that's what I was asking. So I didn't know if they were resolved with a deposition, but now I understand why not. But I would definitely need some type of, before I even kind of went down that road, I don't know how I would resolve these issues with AB.
I think the best way to do it is to see if we can develop. I mean, we can try to do it on our own with the parties beforehand, but I mean, we can also do it in trial. I mean, it's not something we have to mention or go and talk about. And I know the court wants to resolve all these issues. We're also talking about a minor, and then the administrative rules and Florida statutes encourage us to limit the amount of times that minors are discussed, and I'm very cognizant of that. So I mean,
I also agree, but also what I'm hearing from both sides is that Mr. Dreiser said the deposition that he participated in and took of AB wasn't contemplating these issues. I hear the state saying that you always knew.
that's not true, no.
Or like that you knew
No.
that you were going to introduce this state? You did not know.
The statements were provided to us after the deposition.
And, Your Honor,
A year or so.
Right, this is a long time.
we deposed AB and LB, I think in early 2025, late 2024. The state's 10th supplemental exhibit, September 19th, 2025, listed the interview that I provided to Your Honor. And in section C of the state's discovery exhibit, it lists the specific statements outlined by Mr. Dreiser. So the state put those statements specifically outlined in a discovery exhibit dated September 19th, 2025. I think we had some discussion about a follow-up deposition.
When was the depo of AB? You went fast.
Let me give you the exact date, Your Honor.
September.
It was before those statements were
Yes.
disclosed.
Way before. I want to say like close to a year.
A year.
I recollect.
So the deposition of AB was September 20th, 2024. The state disclosed the
September 19th.
September 19th, 2025, the specific statements as relayed in AB's recorded interview, including statements that, quote, he would be better off dead, statements he has a right to die, doesn't deserve to be in this world, was a horrible person and the defendants would not feel bad if he died. I spoke to Mr. Carodi this morning about, obviously the state has no access to AB, and I don't believe Mr. Dreiser had access to her. Mr. Carodi, we were discussing in preparation for trial, the ability for both sides to pre-trial with her. So perhaps that might resolve some of these issues if both sides are allowed to speak with her and develop some of these issues, short of a recorded deposition, but in an informal Zoom pre-trial setting, which I believe there's been at least a loose openness to making that happen.
Mr. Crody,
Her guardians.
do you know?
And what's the question, whether or not?
If AB can be available to both parties to resolve some of these issues so I can make a ruling.
Your Honor, I'm not in a position to make a representation, an absolute representation to the court. I can obviously pass the information along, stress that that would help resolve an important legal issue,
When would you know?
hopefully by close of business Monday.
It takes that long?
It helps for the court to know that involved in this from the beginning. The Gardners have their own lawyers, and you can't just call like a normal like parent. You have to call the Gardner family lawyers, and the family lawyers meet, and the family lawyers talk to the family, and then the family gets back to their lawyers, and their lawyers get back to us and the state. It's not, and the state is acknowledging that is the course, and they're entitled to do it that way, but it's not as one of these normal issues where you just say, go in the hallway and call so-and-so's parents and see if we can talk to them. It just doesn't work like that. And she's on the West Coast, so there's a time difference. There was, I think it's summer now, so there may not be, there was school time issues. So when we did her depo, we did it, I think, starting at 5 p.m. or 7, or it was late on the East Coast. So there's just more issues than typically we see.
So, Your Honor, I will.
So right now, what is it, like not almost 9?
Your Honor, I also believe there may be some travel involved currently. So again, as an officer of court, I don't want to represent the court.
No, I
So do I
just asking questions.
by Monday, by the end of Monday, I can have an answer and communicate that to the parties in the court. I can tell you there were preliminary discussions with, is Ms. Stifler represented, with one of the family representatives, and I think there was understanding that giving access to AB pretrial to all the parties would be in the pursuit of justice and be fair to everyone. So I can pass along as I get information.
All right. Thank you. I'll need to see you. I want the answer, Mr. Crody, and then I need to see you all as soon as you know the answer. So maybe Tuesday.
Yeah, whenever the court is available, the state will make itself available.
And then I'm also hearing that there's no settle agreement related to the motion for bill of particulars, both the first or the second. So I'd ask the state to respond. Before I thought it was settled, like you all were. So if you would respond to that by that date.
No problem.
So I'm going to take the motions under advisement.
Your Honor, as Ms. Nelson alluded to earlier, the Gardner team is unavailable to appear next week, and if we could appear by Zoom and waive the appearance.
Absolutely. I just need it. Honestly, all I need is for, to the extent that you, Mr. Crody, to the extent that you have contact with AB, that you communicate that contact to Mr. Dreiser, the Fernandez team in the state, and then you don't have to be here as far as I'm concerned.
Yes, Your Honor, and for the record, the lawyers do not have contact with AB for Ms. Gardner. Like, we do not have access to her, unfettered access to her. So we will be communicating with the representatives of the family.
Does Mr. Dreiser, does the state have to go through you, or could they contact those lawyers?
You could contact those lawyers.
Why don't y'all do that and just take them out of the loop then?
That would be fine. I've been I've been coordinating through Mr. Carodi, who is courteous enough, and that's how we did trial subpoenas, both Mr. Dreiser and myself, and the Zoom stipulations we went.
Why don't we cut out the middle team that doesn't have direct access?
I did ask for some contact information. If they can provide that to me, I'll do that. That's fine.
I will say, Your Honor, that we adopted the motion with respect to marital privilege, so we're involved also and will be participating anyway.
Would you all be, meaning participating, you want to make your own arguments as well? And if there's proffered information, I don't really care the form, but I do care about, generally speaking, motions in limine are hard to rule on regardless, because generally speaking, the court needs some type of context. This, I thought, was purely legal, but part of it relates to some factual determinations, like how, a lot of times the facts are just agreed on.
Yes, Your Honor. As far as argument on the motion, and we've adopted the motion with respect to the conversations that occurred in the home, obviously we are in a different posture with respect to the communication alleged by Ms. Gardner to Kim Jensen.
Yes, I agree. I'm speaking solely related to AB, solely related to, because, hypothetically, how and when these conversations occurred, it sounds like no one explored. No one knows. All of it is assumption. And so if it was like made in the open air in the kitchen and she wasn't upstairs, was there a marital privilege? That matters,
Yes, Judge.
If it was behind a closed door, as is one of the cases, that matters. And no one's explored it. No one, do y'all even know the answers?
I mean, when the detective asked if they ever talked face to face with Abby about stuff like that, she said no.
Right, but stuff like that, I mean, she could interpret that meaning like they talked directly to me, not I was sitting in the kitchen while they were talking while, whoever was making spaghetti dinner.
Well, it was 25 seconds.
Right.
Like the same conversation.
Well, as lawyers, you all know that direct questions to direct answers, she also said they talked about it for a long time.
Right.
So that the way that police question and the way that lawyers question, two different things. Unless y'all can agree that is like, that all of the statements were made and she was upstairs in her master bedroom and all of the statements they were separated and downstairs and that they weren't intended, then I don't know how to even rule.
Yeah, none of the parties know the specifics to that answer. We can endeavor to do that. The state's position on all this is that it's irrelevant except as a backup. So if the court were to find marital privilege for all these things.
I'm interested, I guess this is the first time I heard the state's theory, because I was always kind of operating that it was BB.
Right,
So-
and I want to point there, because we have taken the deposition. I don't want to spend a lot of time arguing about why we think there's a conspiracy between the defendant and Ms. Gardner. I think the court is aware that there's discussions between the two of them about Jared Bridegan's elimination. We have a specific piece of evidence that is new to the case that we filed our 18th supplemental discovery on. We have taken that witness's deposition. We have not gotten a transcript yet. But in the state's disclosure, I want the court to be, this is directly from the defendant's mouth. So this is substantive evidence of the defendant to this witness that defendant stated that his wife wanted to put a charge on the victim, that he told her they should just kill him. Fernandez stated they didn't want the victim around because of the kids. So that is, I just want the court to be aware we do, and the defense is going to have a lot of cross-examination on the credibility of all of that. But we do have independent, direct evidence that the defendant was doing this for the purpose of eliminating the custody of the children. Therefore, state's theory of abrogation of the husband-wife privilege has been met as previously argued, but we do have evidence the court can look at in our disclosures.
Would you agree that those statements were made?
No, I would not agree that those statements were made. I agree that some 12-time convicted felon heard those statements supposedly from my client in 2024 when he was actually cooperating in another homicide case with that office and doesn't disclose it, gets out of custody, comes back into custody in late June of 2026 on a $5 million bond, and then reaches out after telling his mother to Google it, and then calls the state and says, get me a meeting. And then about 10 days ago, we find out that this snitch from 2 years ago has information, none of which is information that you could not have found on the news. So no, there is not a juror in the world that will believe this person, nor do I believe it would even make the threshold. It's not even a weight for the court to determine the weight of evidence to allow theories, especially in context of a co-conspirator statement. There has to be independent evidence by a preponderance of the evidence that there is a conspiracy, and then whether or not those statements can come in, I don't even think it would make muster with the court of how incredible this human being is. So if that's how they've come up with their new theory, it is, it's so factually disgusting that no one would find it to be credible. And I look forward to them putting that person in front of the jury as to their final admission that they got from Mr. Fernandez, because I don't believe there's any other statements between Mr. Fernandez and Ms. Gardner that they intend on admitting, where he says there's lots of conversations between them as to eliminating Jared Bridegan. There's not. I don't know what they're talking about. There isn't in this case.
Okay.
And I'd be heard. Just briefly.
Yes.
I heard Mr. Dreiser just say the answer to the court's question was yes. There is evidence of that. Whether it's credible or not is a different weight, not the admissibility. There is incredible evidence of a conspiracy in this case beyond the defendant's own admissions that because we're talking, it's hard when you have two different issues. So the regard with the custody issue is not just proven by that person, but is proven by the circumstantial evidence. We do have direct evidence from the defendant about him stating that he was there to help with child custody issues, that he would take care of child custody issues. It's not just this witness. We have multiple witnesses that would testify to that. But we also have overwhelming evidence that there was a conspiracy in this case. We know that multiple people were involved. When the victim was killed, there's a person that fled on foot and a person that fled in a vehicle. We know that Henry Tenon left his DNA behind on that tire, and that we know that Henry Tenon was not driving the pickup truck that fled the scene. And we know that the defendant, Mario Fernandez, has a connection with Tenon based on the relationship of being landlord-tenant, but also their communications between each other. So we know that they have communicated in the days, weeks, and on the day of the particular crime and afterwards, which afterwards statements are not conspiratorial in nature. But we have the other co-conspirator, Shanna Gardner, and this defendant, Mario Fernandez, being the LLC co-managers of the account that ends up paying Henry Tenon. So when the court, all of this evidence establishes the conspiracy. It's just the most easiest one to do it is the jailhouse witness. I want to also, I think I pointed this out before, that the reason why Kim Jensen's involved in conspiracy is she, independent of the ask to find somebody, actually asked. So she took the affirmative step of her own to try to find a person, which shows that they were involved in a conspiracy. So we have ample evidence that both of these people are involved in the conspiracy, and the conspiracy was with regard to the children. And in other words, eliminating the child custody issue. That's the only motive in this case that is really pertinent and significant. And so for those reasons, we don't think the court even needs to get to the finding with regard to AB. However, of course, it's always better to have more reasons to admit evidence than less reasons. And so if the court wants to figure out if that husband-wife privilege was abrogated based on a lack of expectation of privacy, we will endeavor to do that, to see if we can provide the court more information.
Okay, so you do agree. Well, you're agreeing the marital privilege obviously has to be resolved prior to, but before I was under the impression that there was some sort of understanding between the parties, so I am going to ask the state to, in short order, respond to the motion for a bill of particulars, okay?
Not as to the solicitation, we'd be happy to do that.
We have to know how they're getting in co-conspirator statements. It doesn't matter whether it's charged. Ms. Rahi brings that to the court's attention because that, in fact, is the law. Whether it's charged or not is not the analysis. It's whether or not they intend on establishing independently with the evidence in this case that Kim Jensen and Mario Fernandez were in the same conspiracy. Every single case Mr. Mizrahi provided you says that that's what they have to do. So it has nothing to do with the solicitation. If they want to get Kim Jensen to make a statement about what Mario Fernandez said on the theory of a co-conspirator statement, they have to prove independently without that statement that Mario Fernandez and Kim Jensen were participants in the same conspiracy. And I think if you're going to make that argument, you got to tell me when the conspiracy was and what the date range was. And certainly, although there's circles being thrown in the air of what Mario and Henry Tenon have going on and what Shanna Gardner and Kim Jensen, I keep referring back to, you have to link the parties. You have to show that Mario Fernandez joined the conspiracy of Shanna Gardner and Kim. And the only thing that Mr. Mizrahi said that even had a scintilla of argument as to suggesting that they were joined was a payment that exists after the conspiracy ended. Because I once will again say they listed it from November to February, the date of the homicide. The payments are in March. So the one thing that he said that possibly could link the two are outside the conspiracy date ranges.
So I'm looking at the second bill of particulars. It is related to the conspiracy, not the solicitation. It's a request citing the law. So to the extent it's in the papers, I'm asking the state, ordering the state to respond to it.
Our order has been filed by saying we dismiss that count. There's no law under the statement of particulars that we give a statement of particulars as to an uncharged count. It's nonsensical. So I can't provide a statement of particulars on a count that we've dismissed. And Mr. Dreiser is though 90% of the arguments on the legal issues he's been 100% right, 90% right on. He's 100% wrong on the fact that we have to prove that Kim Jensen and Mario Fernandez Saldana were in a conspiracy together. We have, in the case law, is very clear. We have to prove that they are in the same conspiracy. So, as the court's aware, in drug cases, you're going to have multiple people along the train of distributing narcotics that may not talk to each other. So, we do not have to prove that Jensen and Mario agreed together. We have to prove that Kim Jensen and Mario Fernandez Saldana were both part of the same conspiracy, which that conspiracy is the elimination of Jared Bridegan.
He's 100% correct.
Okay, yeah, there you go.
What he's wrong about is they have to prove that Mario Fernandez joined that conspiracy. He's right. They have to be in the same conspiracy.
I just have an issue. So I'm looking at the actual filed document. And if the state's response is that we've dropped that count, then that is the response. And if you want to amend it to what you're asking, we're getting far afield of like what's in the papers is, I guess, my point.
Yeah, the statement of particulars, I believe, is a non-issue at this point. I have provided the evidence to the court, and it's already part of the record, about how Kim Jensen and Shanna Gardner were involved in the conspiracy.
Are you filing that? You want to file these?
File what?
What you handed up.
We can. I mean, I think they're already, they're already part of the record. I mean, it's the transcript.
What I would like to do is instead of, and it's for ease of myself and probably the environment, okay? Like if y'all have transcripts, you can give me an electronic version. It's easier for me to search and look. So.
I mean, we need to, for the.
So I want what is in the record to be complete. To me, that was part of the reason today. So what's in I'm looking at the defendant's second motion for bill of particulars. It relates back to the first one, which talks about the inconsistent dates of the conspiracy. And so that was the ask. And then, so whatever the state's response is, let it be responsive to the papers. And if the state's response is that we dropped it, okay. If you want to amend, amend. And then we're going to be dealing within the scope of what's before the court. And so I'm ordering the state to respond the way you're going to. And then whatever the response is, but we're way out in left field.
All right, well, just know that the trial will be filled with constant, which is fine, that's our job, is to constantly object, and we will, to every single statement that they try to get in until they independently prove that there's a conspiracy. And we'll just guess when that is and hope that.
Or we can try to handle it pre-trial with your papers, but right now, what is before me?
I'm ready for trial.
Okay.
Just go do that.
All right, but I'm going to request, and I'd like, if you all are going to impeach, I'd like for it to be electronic if it could.
Understood.
All right. I can return these back since you're.
Yeah, we'll do it, because we have more to submit, the bond hearing and things like that, if the court wants to look at the.
If you all also, the transcripts, if you could OCR them so they're searchable and put them in order. Like, for example, what I'm asking is if, for example, witness Ms. Jensen, if she's got 3 transcripts, okay, put that in a folder for me so I can click on that so I don't have to search between files. So witness has multiple transcripts, put it in a folder for me so that it's organized that way and I can find it quickly to rule.
And there, if we're moving on from this issue, we do have a state's first motion in limine.
Okay. I'm going to take 10 minutes, okay?
If I may, I'm going down to Judge Cooper's courtroom, real quick, we started detention at 1:30.
Okay.
I'll be right back.
Sure. All right, court's in recess. All right, thank you. Mr. Fernandez is back with us, and we were going to take up the state's first motion in limine docket line 624.
Yes, Your Honor, thank you. May it please the court. The state's first motion in limine has to do with questions of inmates that the state may call in the trial. And I think the law is pretty well settled here that the state of Florida will not object to questions about the pending case of the inmate. And this stems from the defense's motion to strike the witness that we then tabled and redid his deposition, if the court remembers all of that with regard to the invocations and things like this. So I think that the disagreement between the parties comes down to how much into the particular case that the defense can go. And so the state's position, and we cited Jackson v. State, 25 Southern 3rd 518, as a Supreme Court case in 2009, the defense is allowed to say, you are charged with X, you are facing Y. There is a minimum mandatory in your case. You could go to prison for 100 years. You haven't resolved your case yet. It is still pending. We agree that all those are permissible cross-examination statements. The defense has indicated that they want to go further and say not just what you are charged with, but who is the victim of your case. You are accused of shooting your wife. You are accused of disposing of the evidence of the case, and there is evidence to support you throwing away a gun. That's the line that the state feels like is improper, and the court should deny the defense's ability to cross-examine beyond the nature. The word nature, they cite Henry for the proposition that they can get into the nature of the charge. But actually what Henry says is what I've listed in my motion in limine is what they're allowed to get into.
So we agree they can say it's second-degree murder, that he's facing 25 to life, he hasn't resolved his case, he could go to prison for his life, we agree with. What we don't agree with is him saying, and you are accused of shooting your wife and throwing away the firearm, and facts that go into, in detail, that are still disputed by the defendant as he's pled not guilty. And the phrasing of, this is what the state has accused you of, doesn't save their inability to go into those specific facts. Okay. So I think their argument is that, well, he won't even vote because we're just saying what the state's accusing him of. But that still goes into the facts of his case and is not relevant for bias.
Right, Mr. Hill?
Yes, ma'am. Your Honor, I want to let the court know exactly what witness we're going to be dealing with and what we experienced when we were in depositions. This is Emmanuel Alexander. He came into his deposition and told us that he had been in no short of 7 to 10 or more car wrecks over the history of his life with traumatic brain injuries, and his memory was worse after every single car accident. He had had multiple drug overdose and suicide attempts in which his memory continued to get worse. He self-diagnosed himself with dementia, and when questioned, could not remember his conversations with the state attorney's office the day prior to our second deposition, when we had placed the motion to strike the witness on hold in order to conclude that deposition. So we have a couple different issues that are a little more than just simply his bias, but also his ability to accurately remember, which goes to what will be one of the standard jury instructions provided to the jury, which is 3.9, weighing of the evidence, which is going to be whether or not he has a memory to accurately reflect on the stuff that he's testifying to. So, but I want to kind of start back at the beginning because Mr. Mizrahi brought up what we are allowed to question, which we're in agreement. I'm allowed to ask him what he is charged with, what his maximum punishment is, whether he's been offered any favor by the state attorney's office. We have no disagreement on that. I do believe that we're allowed to ask him, and the reason I say this is that we're allowed to ask him, you've been charged with attempted second-degree murder or you've been alleged to have shot your wife. The reason I bring that up is because he specifically states in his sworn statement that was provided in discovery, which would be page 4 of 11 of his sworn statement, it's not been filed with the court, that he states, the thing that made me sour in the relationship with Mr. Fernandez is when he used profanity towards the victim's wife and widow. I think it's important that the jury would be able to weigh his credibility where he's saying, I'm so offended that Mr. Fernandez used the B word and the C word in describing how he felt about Ms. Bridegan, but at the same time, he's charged with shooting his own wife. And so I do believe that goes into weighing his credibility with regards to the jury's ultimate fact-finding. He's not going to be asked to admit whether he did those things because, as I mentioned, he says he has no memory of anything. He said that in an evaluation where he has amnesia, doesn't remember the events at all. He's also been accused by the defense of tampering with evidence in this case. The discovery provided by the state includes handwritten notes by Mr. Alexander, which we believe he's tampering with evidence in our case, and in the case that he has pending before your honor in his own case, he also has a tampering with evidence charge, which is specifically throwing the firearm into the woods, which is captured on Ring camera. Again, he says he doesn't remember anything. He acknowledges that he has seen discovery that purports to show him throwing and tampering with evidence by throwing this very firearm into the woods. We believe that is relevant. Our defense to this witness is he's tampering with evidence. He has no memory of his discussions with the state or with other people, and on one occasion couldn't remember a question I asked him 2 or 3 minutes into his deposition, and that he has denied that he tampers with evidence, that he's pled not guilty, and we're not going to ask him whether or not he is guilty. I can envision asking him, do you recall that the state has charged you with tampering with evidence? And he'll say, yes. I imagine he'll say, I recall they've done that. If he says no, we'll ask him, Mr. Alexander, have you seen a video of, in fact, what the state alleges is you tampering with evidence? We believe that's absolutely relevant because the jury's going to have to determine whether he has an accurate memory, which goes to his credibility. As to the statements regarding his wife, I think it correlates back to what he says was so offensive that led him to come and cooperate against Mr. Fernandez, was that Mr. Fernandez used profanity But the jury should also know that though we're not going to ask him whether he did it, that he's charged with attempted second-degree murder of shooting his own wife. So the jury should be able to weigh that evidence as far as, okay, he says he came forward because he was so offended, but yet he's also accused of shooting his own wife, because that is a big conflict in his position. To be offended by words, but in essence not offended by shooting his wife, for which we're never going to ask him if he did that. He's pled not guilty. We have no reason to ask him something that would invade upon his Fifth Amendment right. I did cite, or I did forward to the court as well as to Mr. Mizrahi, but it's stated and cited within the Henry case, which is the Bell case, which the court did allow questions about what charges an individual had, and that defendant tried to invoke his Fifth Amendment right. At the time, the court sustained that. It was reversed and said that those questions were permissible, but they further went on to cite these were matters of public record. And specifically, matters of public record, we have the information that was filed by against Mr. Alexander by Christina Stifler as to count 1, attempted murder in the second degree, attempt to kill Tasha Alexander, a human being, by shooting said Tasha Alexander, and during the commission, the aforementioned attempted murder in the second degree, Mr. Alexander did actually possess and discharge a firearm. So I'm not asking him any questions that are not a matter of public record and do not invade upon his Fifth Amendment right. The state wants to limit it to simply saying, you're charged with attempted second-degree murder, you're facing a 25-year mandatory minimum. They're bringing this witness in who, by their own admission, he's not a great witness, he's charged with terrible crimes. They've not offered him any type of plea deal, he's not pled, but they also want to sanitize this witness so that when the jury hears how offended this witness was by the alleged statements of Mr. Fernandez, they can't also know that he is charged with attempting to kill his own wife. So it seems disproportionate, and they claim that there's some prejudice that they would suffer as a result. In paragraph 3 of the motion, the prejudicial effect of such evidence or inference outweighs the probative value. I've yet to hear what the prejudice is to simply stating what is in the public record and asking Mr. Alexander to acknowledge that that is what he's been charged with. Whether he acknowledges he did it, we're not going to ask that question. The Henry case specifically, though we did cite it in a previously withdrawn motion, that was about asking about plea deals and inquiring into that. And one thing that's important is that that was reversed because there is wide latitude on cross-examination. That's a Sixth Amendment Confrontation Clause issue, and the courts regularly are reminded that there is latitude for the defense to explore because credibility of what is going to be a key witness in the state's presentation against Mr. Fernandez, he should be able to inquire for the jury's benefit as to the nature and specifics of the charges in which he faces. The Jackson case, that was asking this witness whether he that was for a kidnapping trial and is being cited simply to state that the question that we're asking does not establish bias, but it's not limited to bias, as I mentioned. This goes to specifically the weighing of the evidence and whether this witness has an accurate memory. I anticipate he's going to take the witness stand and says he doesn't remember a lot of things. That was kind of a theme of our deposition. I don't think Mr. Mizrahi will disagree that Mr. Alexander, on many occasions, probably far too many to count, would say that he doesn't remember and would apologize at how poor his memory was, which ultimately led to him telling us that he believed he had some sort of dementia. So I believe that the Jackson case, though it is a Supreme Court case, is isolated to bias. But again, the reason we're seeking to expand upon just asking what he's charged with and simply allowing us to expand on the nature of the charge and the specifics, he's charged with attempted second-degree murder, alleged to have shot his wife, that she is the victim. As far as what's important for the court to note, I do think the Bell case is also instructive, is that the examination is not limited simply to the facts that were pending against the witness. It states that the inquiry can be made regarding the specific nature of those charges. That case has been emailed to Your Honor. It was also cited in Henry, but that's Bell v. State, 614 Southern 2nd 562 out of the 3rd District in 1993. I think it would be impermissible to allow Mr. Alexander to hide behind just the words of the charge itself and not allow what's in the public record to be asked of him because he's placed that at issue. Once he said he was offended by the statements of Mr. Fernandez, I do think it's ripe and appropriate for cross-examination to simply state, Mr. Alexander, you've been charged with attempted second-degree murder for allegedly shooting your wife. And that's what's stated in the information, which is public record. The tampering with evidence, again, not to belabor the point, but we did state that we believe the defense of this witness, and he will come in and state that he handwrote notes pertaining to this case, his own case, as far as how it included Judge Kite. And we do believe that it does show that he has a history of tampering with evidence. I anticipate he'll do what he did in his deposition when he didn't want to answer a question, is that he'll simply say, I'm sorry, Mr. Hill, I just have a really bad memory. I do a lot of drugs. I've had a lot of head injuries. And asking him whether he's aware, which he did answer in the affirmative, that there's a video that purports to show him tampering with evidence, I think also is appropriate for cross-examination.
Isn't what the defense is arguing almost as if door opening, meaning that it has to kind of occur before you can delve deeper for it to be wide latitude? Correct me if I'm wrong, what I hear, so first issue, he is so offended. I know that might be prior testimony. He may be cross-examined on his reasoning why. Isn't it dependent upon his answer in open court about where you go from there? So it's almost like A and B have to occur before you can go to C, which is kind of beyond and delve in to then impeach or to show additional bias. And so so that's my first question. The second question is what I hear you say, which is the evidence tampering. Isn't it also dependent upon, you're saying, well, he's gonna feign a lack of memory, so therefore I should be able to ask on cross-examination, isn't it true that, I don't think anyone is disputing that you can say you have been charged with evidence tampering and it's pending, but then the second thing is now you get to introduce facts. This is my question. I don't believe the rules of evidence would allow you to then go into, and then introduce a fact that is outside of when he feigns or if he cannot remember. Cannot remember is a refreshing situation, is not an impeaching situation. And so then he has to be refreshed about what you're even referring to before he can be impeached with or ask questions about, because the rules of evidence do not allow a party to introduce facts that aren't a part of the universe of facts to somehow impeach him. So on question one, isn't this just a door opening situation? And then it has to happen kind of real time.
So to answer question one, I don't necessarily disagree with the court. However, the state filed a motion in limine in anticipation that that's what would happen.
Right. Okay? So we're in hypothetical land.
So when the state and I and our various teams were in this deposition for a period of 2 days, a lot of the responses were, I don't remember, and we were back and forth with this individual's memory. And with the statements regarding how offended he was about what Mr. Fernandez said. The state asked if we were going to go into this, and we said yes. Hence why they filed this motion in limine. Okay. So I don't necessarily disagree with you. I think the reason we withdrew our motion to strike this witness is we said this may end up being more of a trial issue at this point. But the state then filed their motion in limine, which led us here today. I don't know what he's going to say in trial, but I anticipate he's going to say something to the effect regarding his memory. That's why the tampering becomes relevant. And with regards to his statements of how offended he was, I do think at that point, if that testimony is consistent based upon the sworn statement he provided to the state, which I anticipate they'll ask him, why did you come forward, Mr. Alexander? You've not pled to your charges. We've not offered you a plea deal. He's going to say, I was so offended by these statements by Mr. Fernandez. When that was made clear that we then were asking him, aren't you also charged with shooting your own wife? How do you reconcile being offended by bad language but not being offended by the allegation that you shot your wife? We didn't go into asking him specifics of whether he did or didn't because he has a Fifth Amendment right, and we didn't invade that right. So the state did file their motion. That's why we're here. That's why we're seeking guidance. I do believe, and we did discuss that we thought it was more of a trial issue once he said whatever he was going to say. I don't know if
I think we have to wait until he says what he's going to say.
I disagree, Your Honor.
How so? I mean,
It doesn't matter what he says. The only way this stuff comes in is for bias. That's it. You can't talk, he has not been convicted of anything. They are trying, he actually said it in his argument just 2 seconds ago, that they can't go further. Let's assume that the witness's response to all of this is, I'm not guilty of that. That's why I wasn't insulted by it. He has a pending case, and a Fifth Amendment right to remain silent, and he cannot be impeached based on our allegations. He can be impeached based on the bias that he has because he's facing these time, and that's why that's admissible. He is facing life imprisonment, therefore they're allowed to cross-examine him. Isn't it true you're just testifying to get a good deal from the state? What they cannot do is say, isn't it true that you're not insulted by women because you shot your wife, or under the guise of you're accused of shooting your wife? He has no ability to respond to that. It's a pending case. It's not proper impeachment under any set of circumstances. If he were convicted of the charge, it would not be proper. In the Jackson case, which was reversed, the defense called a witness that was disgruntled with the state of Florida based on the charges that he received. And if you read the Jackson case, they called him, and we are allowed to cross-examine the defense witness that he had he got, quote, walloped with a 25-year sentence, and he thinks he was wrongly accused. Therefore, he has a bias against the state of Florida to come testify. The prosecutor in the Jackson case went further to say, and isn't it true that you were convicted of aggravated manslaughter? And then in closing, the court allowed that, and then in closing said he's a baby killer. And the court said, you can't do that. That has nothing to do with the bias. You can't go into prior cases and collateral impeachment on a witness and opening up a pending case by doing that. So let's assume for a second that he'll say that. I mean, he probably will. He said it in depo. I don't know what he's going to say in trial. But even if he said it in trial, I was offended and that's why I came forward, it doesn't give them the right to impeach him on the state of Florida's allegation. If they had some impeachment that he had, I don't even know a situation, he had said previously that he's not offended by people making fun of women, maybe that would be admissible. It's hard to come up with a scenario where it would be, but let's say they have a witness that says he hates women. Yeah, maybe they could call that person to impeach. They say he's insulted by women. But they can't use a charge from the state of Florida to impeach his statement. I don't see a way that that comes in. Thank you. And certainly, I guess I would agree with the court to the extent that this is a situation that we can deal with in trial. I mean, I don't think we need I just wanted to put, when I knew that there was an issue out there that the parties couldn't resolve, I wanted to put it on the court's radar. But I don't see a scenario where it's admissible.
give me a moment, okay? Case that went back.
I've read that case.
Did you, Mr. Hill? Breedlove, 580 Southern 2nd, 605.
I see it cited here on the second page. I
Yes.
don't know it off the top of my head. I can pull it up and read it briefly.
I think it's appropriate to stay within the bounds of what is before the court, which is, so as to the first, I think we're just restating what we all know, which is, yes, those are the permissible grounds that you would be able to explore on cross-examination. No one can foresee the future. So to that extent, I'm going to grant the state's motion in limine. If you believe that in some way he has opened the door to additional questions, I think Breedlove gives a little bit, not exactly on point, but Breedlove, at least the Florida Supreme Court, talks about the matters of pending, which we all have kind of dealt with all the time. You have a pending case, the nature of the charges, meaning what is of public record. I don't see any preclusion from you doing that. The allegations that he has, the time he's looking at, I think we're all in agreement. But before the defense goes into basically an equation, that is, I think he has to offer it. He has to offer it as a reason why, his compelling reason. And then is it in the interest of justice for you to go further than what is normally allowed by law? I think that's a game time decision. And it's generally accepted that before there is an area that you believe a quote unquote door opening, then you seek guidance from the court before you do it, before you ask the question instead of blurting it out. Breedlove talks about not only pending cases, but also investigation cases. Breedlove also talks about how related maybe investigations are to what is currently being put before the court. And the court, in an analysis, talks about the interest of justice and fairness, and maybe those are considerations that I would take into account at or near the time. But I think we all know what the law is related to cross-examination. It is wide. It's not, there is some curtailing to it based on these issues that are discussed in there. And so what I'm going to grant the state's motion. Before you go outside of what is normally done, Mr. Hill, I'm going to ask that you seek guidance from the court that the door has been opened, and I'll give you the guidance from there. But let him do it. So we don't know what he's going to do, what he's going to say. The state doesn't know. Apparently, you don't know, and so but I'm going to grant it at this point because I believe that to be the current state of the law. And so the impeachment, you can't get to impeachment until, an impeachment can come on feigning lack of memory, but there is a showing that's required by the rules of evidence. But you can't impeach, I don't know, or I can't remember until you go through the steps to do it.
And I understand the court's ruling. With regards to the nature and the specific nature of the charges, I haven't seen where this has been specifically addressed, and I'll go back and read Breedlove, but with regards to the 3 charges Mr. Alexander has pending, the charges are stated in 2 different ways on the information. As the court knows, we have the just bulleted, attempted second-degree murder, possession of firearm by convicted felon, tampering with evidence. But then further down, when it actually explains those nature of the charges, I want to make sure I'm clear with the court's ruling.
I think that,
that's just what I want to make sure I'm clear
on. Sure. I think that you can go into, you're charged with attempted second-degree murder. And there's a firearms enhancement. All that is fair game. I don't think the state's objecting to that, are you?
I'm not. I think he wants to read the information that the alleged victim's name and then go further. I think what Mr. Hill is asking is to read the information, which I do have an objection to. I don't have an objection for him to say, I'm charged with the attempted second-degree murder and facing a 25-year minimum up to life imprisonment and tampering with evidence. I think the case law is clear that that's admissible. But he's starting to talk about who the alleged victims are, and that's the facts of the case. For all I know, the witness could be saying, I've never met that woman a day in my life. I don't know why I'm charged with her. I don't know who she is. I didn't shoot any women.
And that may be his answer.
Well, but that's the point is we're getting into a charged offense where he has a Fifth Amendment right, and it's not relevant to any material issue in the case. The material issue in this case is whether or not he's biased, and the charges and the amount how much time he faced goes directly to that, and that's why it's admissible.
So in Bell, the 2 questions that were posed to the witness where it was found that the Fifth Amendment was, the court should have allowed the answer. It was, you've been charged by indictment of X crime. That has been, basically, the witness should have been permitted to answer that question. I can go, hold on.
Same thing.
You're not going to suggest it because he hasn't been charged.
No, you can talk about you've been arrested as well, and it's pending. I agree with it. You can't, yeah. You can't go. My objection would be you're charged with your children. Yeah, yeah.
I can go back to Jackson, but maybe we're splitting hairs, but saying you plan on reading the information to him?
So again, this kind of goes back to the court's first question. We're kind of going off what we anticipate his answers may be based upon his lack of memory throughout his deposition. There was some confusion for him as to what he was actually charged with. He would have to consult with his lawyer.
Really?
Yeah?
Well, I mean, I don't, right now, where I'm at is that ask the normal questions. We have to see, I guess, what he decides he's going to end up doing. If he says he doesn't remember what charges that he has, then, I mean, then they can go up with the information and put it in front of his face and say, you haven't seen anything like that, and they can start reading from it. They can do all kinds of things, and I think we're too far afield into hypothetical land. Right now, I'm going to grant the state's motion. We'll see what he's going to do, and it's going to be a game time decision about how far they can go or not. If he's going to be that, from what y'all are describing, if he's going to be that uncooperative, I think that they can go through the normal means to either refresh his memory, to ask him questions.
I don't, that's a different, if he says, I don't know what I'm charged with, that's a whole different
Right.
ballgame.
I mean, I don't know. And y'all don't, it doesn't seem like y'all know, so.
He says he doesn't know. I've never said I don't know what the witness is.
Okay, well,
I don't know what any witness is ever going to testify to.
right.
Until
Well,
they get on the
I'm
witness
just saying, I think that we're getting too far. Like, could that happen? Yes, I think so. But right now, I'm within the, ask him the normal questions.
I understand, Judge.
Okay.
They filed their motion, so we had to.
All right, no, I get it. So at this point in time, is granted without prejudice to re-raise. Okay,
Thank you, Your Honor.
thank you. Is there anything else for today?
No, Your Honor. We can. Your Honor, the defense filed a judicial notice request of Your Honor.
And I saw there was an objection.
We objected to it, so.
It was about the firearm, right?
We simply want the court to take judicial notice of the fact that the FBI used that firearm from whatever it is, 1986 to like 1996. For the purposes of today, it doesn't matter. That, ironically, the state doesn't disagree that that is a fact. They don't disagree that the FBI used that firearm and then discontinued it. What Mr. Mizrahi, as I anticipate, although today he keeps telling me I'm wrong, my anticipations is they want more information. They want the jury to know that it wasn't the greatest firearm. It didn't work good. It had a high recoil, whatever the case may be. And as Mr. Mizrahi said to me, facts that come in as judicial notice have to be facts that there's no disagreement upon. And ironically, the example that he gave me was it's 72 degrees outside. That would be something the court could take judicial notice of. But neither party disagree in this case that it's 72 degrees outside. What Mr. Mizrahi tells me is
Yeah, but I want to know more. Well, maybe it's 72 degrees outside because of global warming. That there would not be an agreement on. Maybe it's 72 degrees outside because there was an extreme heat wave in Alaska. That would not be. But the very idea that it's 72 degrees outside, stop. The state does not disagree. And what it says is facts that are not subject to dispute because they are capable of accurate and ready determination by resort to sources whose accuracy cannot be questioned. I provided them with a letter from the director of the FBI when they started using the firearm, and I provided them with evidence that the firearm stopped being used. And they don't disagree with my sources. They have told me they don't disagree that their experts and the people they've consulted with and the gun enthusiasts in their office all know that this is a fact. They just don't like that that fact alone is coming in. They can call anybody they want to put in whatever information they want about the 10 millimeter. I just don't want to be in a position to have to pay somebody, although I've already listed somebody from the FBI who I will call on Zoom to put that fact in if I have to, when there's no dispute as to that fact. I'm not preventing the state from putting in other facts if they so choose. If they're going to call someone from the FDLE who's a firearms expert, and they're going to say, what was the problem with the 10 millimeter? It had high recoil, it had high velocity. That's it, fine. Maybe if they know something about the 10 millimeter, I'll get a bunch of testimony out that it's not all that rare of a firearm. Millions of them are made, and every manufacturer has made that firearm. I'll take advantage. But it is not subject to dispute that it was the issued standard firearm of the FBI from 1989 to 1997.
Okay, thank you.
And our objection is multiple faceted. I think the notice was asking that it was a 10 millimeter. The 10 millimeter, in regard to this case, our firearms expert would testify that it was a Glock 10 millimeter. The FBI firearm was a Smith & Wesson 10 millimeter. These are the kind of nuances. What the defense is asking you to take judicial notice of is essentially DNA is unique between everyone except identical twins. These are not facts that typically are judicially noticed. While I agree that the FBI may have had, and in all likelihood did, issued a 10 millimeter firearm during the specific years in question, that is not a statute or a regarded temperature at a particular time. And so we don't think this is appropriate for judicial notice, and would ask the court to deny it. And certainly the defense has already listed somebody that can certainly cross-examine any of our witnesses that have the information about what the FBI may have had. I don't see this as an issue that needs to be judicially noticed. It won't take any more time from the jury. It's not a complicated issue. Judicial notice is usually about, these are the laws of Kentucky. This is the registry of something. The person was on probation, whatever the case may be. So I don't think this is appropriate for judicial notice. We have objected to it and thinks that kind of evidence that needs to be presented is evidence that should be subject to cross-examination.
Okay, Mr. Dreiss, I'll give you last word.
I don't have anything further.
Okay. All right, I'll issue an order on it. All right, thank you. Court's adjourned.
Okay, so as you can see, so that's the end of court, right? Where they took up all the motions. So I tried to find, I don't know if part of it was live stream or what they did, but on August the 4th, they did have another hearing. I did not see the live stream for it, but I do have what the judge decided in regards to the motion. So we're gonna go over that really quick. Before we wrap up our day here. For those that are late arrivals, just remember, jury selection for Mario starts on August the 10th. So they'll be in jury selection starting tomorrow. And then the trial is going to begin, quote unquote, supposedly on August the 17th. If anything changes, I will be monitoring and watching out for it. Just so you guys know. Let's get here. Let's see. So I guess let's work backwards. We'll work backwards here, okay? Let me see what she did. And this is with this witness that they were just talking about, Mr. Alexander. I don't even know how he even could fix his mouth to talk about somebody. The reason why he stopped talking to Mario is because Mario used I guess, bad language or derogatory language towards his wife when he's actually in jail for completely attempting to unalive his wife. Like, how dare you? Like, that's beyond calling the kettle black. So yeah, if he get up on that stand, I want them to talk about how, hey, you did this, and this, and this. Like, really, dude? No. So this is the motion that they were talking about in regards to Mr. Alexander and his testimony coming in. The judge did grant that to the state, as you just heard. So the defense had filed it on July the 10th, 2026. So that's the motion that we just heard, and she ruled on that one. The ones that I really want to go over is the ones that she did not rule on, and she was like, I'm going to come back to you guys, okay? Okay, so here we go. So in regards to AB, which is one of the children, correct? Well, one of the children. I am correct, okay? So the judge actually granted the defendant's motion for this one, guys. So just so y'all know, so the order was granted in regards to the motion to limine to prevent the introduction of hearsay and impermissible testimony. The cause came before the court. Defendant's second motion in limine to prevent the introduction of hearsay and impermissible testimony. It was filed on July the 28th, 2026. We just heard the arguments in regards to this. Defendants Mario Fernandez Saldana and Shanna Gardner have been married since 2018. The charges state both defendants in connection with the February 16, 2022 shooting death of Jared Bridegan in Jacksonville, Florida. Before marrying Fernandez Saldana, Shanna Gardner was married to Jared Bridegan. During the hearing, the defense stated that the parties dissolved their marriage and established custody arrangements for their children through a series of consent orders. The defense also claimed that the family law record reflects that the parties agreed to 50-50 time sharing and later made additional modifications when Bridegan moved to Utah, and then he returned, who was in the car at the time of the shooting. Jared Bridegan and Kirsten Bridegan of either children. So it got it redacted in regards to the kids. Okay, so in this motion, as we heard the arguments, defendant Mario seeks for the court to prevent the state from eliciting testimony from AB. AB is the common child between Shanna and Jared, okay? So, the one thing that I didn't understand about this is that she was at the age like 9 or 10 years. She was 9 when her dad passed away. I wonder why she never said anything that she heard them having this conversation, maybe to like her stepmom or to her dad. Like, I overheard mom and, Mario talking about you, how, I wonder why she never said anything, but that's neither here nor there. Not sure. It seems like they were kind of like mama kids. Sometimes you get the kids that like mama can do no wrong. Like, it's nothing that she can do wrong. And I think this is kind of the relationship that they may have had. But she overheard Mario and his wife, which is Shanna, discussing their feelings about her father and their desire for him to die. During the hearing, the court reviewed in camera a video recording of AB's interview with Detective Irvins of the New Handover County Sheriff's Office, during which AB was questioned about what she had heard and general context and what she had, which she heard it in. It heard it. In that interview, AB described hearing conversations between Mario and Shanna, her mother. According to the statement, AB described the physical settings as follows. At my house in Florida, it was a 2-story house and she was on the 2nd floor, and we heard that. And I had a master bedroom, so I had covered like the whole house pretty much. And you can hear what they talked about. And they would just be like, quote, oh, he better off dead, or something like that. Specifically, when asked about the time frame, AB stated. So they did it like for months, and it was kind of off and on when they would talk about it. But they did it like before he died, and then they didn't talk about it as much during the 2 months after. But after, they kind of talked about it. So the detective said, who is they? And AB responded, her mom and Mario. Okay? So ultimately, the court learned that AB was deposed on September the 20th, 2024. So just kind of like getting down to this part. So we heard about the parties' positions because they both argued this right there, in front of us. I don't want to repeat what we just heard. So let's just get down to the ruling. So she says, having considered the arguments and evidence from the hearing, the court finds that the statements defendant made to his wife, Shanna Gardner, were marital communications made with a reasonable expectation that they will remain private. The only evidence before the court regarding the reasonableness is that the couple had these marital communication in a well-segregated area of their personal home, outside the presence of others. The court is unconvinced by the state's argument that the Section 90.504(3)B applies to these statements through an authenticated crime against Shanna Gardner's children. Therefore, defendant's motion is granted with respect to marital communication AB overheard in the home. The state may, without prejudice, move for the court to consider additional evidence that calls into question the reasonableness of the couple's expectation of privacy regarding these communications or other admissibility grounds. Okay? So she granted this, and she said she put it up under marital. Do you guys agree with that? That is marital? And she signed it on August the 6th. And I'm just thinking to myself, why didn't she go tell nobody? I don't know. I think I would have been saying something. Yeah. Yeah, because I guess if you're having a private conversation with your wife or your significant other, I just wish he would have said something before now. But, you can never, you would have never think something like this would have happened. Okay, and then our next order in regards to our talkative doggone friend, Kimmy. Let me make sure I got the right. Okay, yeah, because it was the same kind of context. So let's go over that one. Because it has something to do with this marital stuff again, okay? So here is also another order granting defendant's first motion in limine. So this was the first one. I read them backwards. Sorry, I just read the second one instead of the first. Whatever, y'all get me. So we heard the argument in regards to the statements that Shanna had with Kimmy, the one that was on the couch that wanted to talk too much. In this motion, defendant Mario seeks the court order preventing, let me make sure, see if I can make this, okay. Preventing the state to elicit testimony from Kim Jensen in regarding Shanna Gardner's account of the conversation between the defendant Gardner and defendant Fernandez Mario, because I'm about to be tearing up his last name because I want to say it all types of different times. So I guess we heard the testimony that what she said in front of the grand jury. She didn't even remember which Hawaii trip they were on. It's to my understanding that they went to Hawaii all types of different times. We did hear the state argue their case. We also heard the defense argue their position. And then the conclusion comes down here to what the judge says. She says, based on the motion and the argument at the hearing, there is no evidence rebutting defendant's contention that these statements were made in the confidence to his wife. He was talking to wifey, Shanna. The original exchange appears to fallacially private. Moreover, there is no evidence that there was not reasonable expectation of privacy at the time of the conversation. Okay, so that is out also. So Kimmy is not going to be able to get up there and testify to, I don't know what she coming here and testifying to in regards to it, because you remember she was the same person. I guess she comes in and she say, well, she knew that Shanna was looking for a hitman, and she reached out to Sarah in order to find a hitman in regards to the text messages. Maybe that's how they're going to get some text messages in regards to it. I'm not sure, because I guess that's what she would have to do, because remember, the cases are not together, and Mario was not directly text messaging with Kimmy. So there's that. So at pretrial, the state dropped the child abuse count as to the state did not contest either assertion. So I think that when we talk about the child, I told you in regards to the baby who is now, she should be 6 because she was 2 at the time, or close to 6, or maybe she's 7. I have no clue. But, with them dropping those charges, that won't be something that baby girl will have to come in there and testify to. I don't know her name, but the baby will not have to testify to. So they saying she's saying the state may seek to introduce the statements upon a proffer identifying the exact testimony, the purpose for which is offered, it is offered, a specific statutory basis for each hearsay layer, the factual predicate for any co-conspirator theory, and the factual basis for any privilege defeating theory, including the timing of the conversation relative to the marriage. So that one was also decided on too. So, and we heard her at the end saying that Alexander's testimony can come in. His testimony can come in, but that's going to be interesting to see. And I wonder how the jury's going to take that. Like, how dare you sit up on this stand and say, hey, nah, I ain't want to mess with Mario because Mario cussed out his wife, and, I don't like how he disrespect her, but, I'm currently in custody because, I tried to take my wife's whole life. Like, how dare you? I can't even say it's called in the kettle black. Like, don't be calling or throwing rocks in the glass house. I don't even know what to say for that. Like, if this is the best that they coming up with for the prosecution team, that they got to bring a witness that I just think that is probably not that great. I don't know. I don't know how I might feel about that, guys. That's all. But so far that takes care of everything that we have going on for today for our third stream. I will see if we will start getting into some of the motion hearings in regards to Shanna, depending on how our week goes. Guys, you do know that we are going to be in multiple courtrooms tomorrow. We're going to wing it. We're going to wing it, guys. We're going to do the best that we can. We do have Courtney. That's going to be the first. I think the first one, I have Courtney scheduled early in the morning. I don't know if they're going to start on time or not. I do know that our trial with Lindsay Clancy, that typically does not start in a timely fashion. I do want to see Reddington's Cross, right? I've been like, I'm like so waiting on that I don't even know what to do about that part. So we will plan on looking at Courtney to see what happens in her hearing tomorrow. I'm not sure how many victim impact statements they're going to have, what the arguments are going to be, considering that's a plea deal. And I'm assuming that the judge is going to probably accept it. I don't know if he's going to have them come back. I have seen times where the judge accepts the plea deal and then they come back for like impact statements and things. I'm not sure with this one if that's what they're going to do. We shall see. I don't know if they're going to do it like we had in our guy Coates trial. Remember, he entered a plea. The judge accepted his plea, and the state put on evidence for 3-4 days. Are we about to walk into something like that? Remember, without them putting on the evidence, we wouldn't seen the things that we seen about Coates. So I'm wondering, like, are they going to do the same thing with Courtney, where we going to kind of have like a mini trial? So I don't know. So we're definitely going into Courtney first. We will watch Lindsay. We'll probably watch that. We'll probably be the afternoon crew for that one. And I will keep an eye out on jury selection for our Tupac trial, considering is probably, probably a lot of people know Tupac. I don't know how long they'll take for their jury selection, but they are on the West Coast time, so they are 3 hours behind Florida and Massachusetts and things like that. So we'll just kind of play it by ear. Okay. So that is basically my plan for us over here. I almost thought that we were going to have to try to figure out how to do opening statements with this case, but it seems like their jury selection, it sounds like the judge is not planning on starting the actual trial for Mario until August 17th. So I'm going to keep my fingers crossed, hoping that happens. So that'll give us a little breather where we're only in 2 trials, which would be Lindsay and our Tupac redrum trial. Okay? Does that sound like a plan, guys? I know that Merelda, if you still in the chat, can you please drop the link for Angel Eyes? He is having a stream tonight. Let me see what he is going to be I know I just hit the alert for him the other day. I didn't even look at what he was covering. I just said, okay, I'll be over there. I want to say it was kind of later. Let me see. So guys, if you haven't already, please go check out Angel Eyes. Very nice channel, deep dives. Wonderful men's panel. I went over there and I was like, oh gosh, I'm like loving hearing, men bring up topics and talk about different mental health, different issues that we have in our community, just from a men's perspective. I was like, oh, okay, that's what they do over there. Let me see. I don't know where all subscriptions. I'm like, where's all my subscriptions at? Oh, here we go. Okay, let me go look. His live. Let me see what time it starts. Okay, so it's scheduled for today. It's scheduled at 3:05. It say 3:05 my time, so I'm assuming that's like 7:05 East Coast time, guys. If you guys want to go over and hang out, let me share Or if not, just go over there and subscribe. So that way when the next time when he gives, has a post, you guys can, or live, you can go hang out with him. Thank you so much, Marilda, for doing that. Yeah, so it looks like his starts in about 15, 20 minutes, guys. Wonderful panel, wonderful group. I like the chat. And he's going to be discussing, that was the point. That was what I was going over there to do. He is going to be discussing the Lindsay Clancy trial, guys. So he'll be giving some discussion on that. I'm not sure if it's open panel tonight, but I guess we'll check it out when we get over there. Yeah, because I think some stuff he puts on here, open panel, but I don't see open panel for this one, but maybe it'll turn into an open panel once we get all over there and get to talking, and maybe he'll decide to open it up. Yeah, it's like 15 minutes for now. Yep, so I'm gonna take a little break. I'm glad I got done in enough time. We got done over here. And then for those, I think we going into the vault with a rewatch for trivia for anybody that wants to do trivia. That starts at 4:30 West Coast time and 7:30 East Coast time. If you want to go hang out in the chat with therapists, and Rachel. It is going to be a rewatch because we know our dear friend Rachel, she is doing real life stuff, right? But I want to say shout out to the mods, shout out to the chat. I appreciate all the newbies. I appreciate all the new subscribers. We are going to be in these courtrooms. We will be busy. I mean busy. I know it was a point in time where I would be like running 2 live streams where I have people in one courtroom and people in another courtroom. And I was like, well, I'm hoping that we don't have to get to that point tomorrow. Like, I'm not going to do that to us, but I really want to kind of like keep us all together, hanging out together, and we just get it all done as a family together. And I like interacting with everybody. Yes, trivia is a replay. When you see the vault ones, it's just a replay like we had last weekend. So, totally up to you. But yeah, it is a replay because they're not doing a live right now. I think they said they'll be back in September. Okay? All right, guys, I'm going to put our outro song on. I will see you guys at the top of the hour at 6 a.m. to see what Courtney, I don't know, does she stick out her tongue? Does she do this? I don't know. What does she do in the courtroom? I can't wait to see. I do know that I'm probably going to be pissed off. I will say it right now because I think that she only going to get about 6 more years to serve, and I am not happy. I am not happy about that, but that's what I done heard through the grapevine, but we shall see how this goes off, okay? All right, guys, I'm put our outro song on, and I will see you guys in the morning.
When Sweet Pete's absent, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, chatter showing out. This little YouTube corner's what community's about. Therapists you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mom like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Maria from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we're forever. for fun. The resident cheater, but we love him, everyone. Here comes Matty, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This Courtroom crew is everything we admire. Yeah, no matter what the case or file, we're forever taken to trial. Take it to trial. Shamrock keeps us trending, replay queen, holding down the algorithm like a machine. SD's razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white claws, way managing volunteers like she runs the whole land. Cynthia brings inside what takes sharp and steady. Donna keeps it real, 911 and always ready. Tilly Bird's the fat queen, receipts on tap. Easy's new, but she blends right into the pack. Tennessee, hard-lived, try support her with pride. Melly shows up a family for cooking for his dog. A steady carrying presence through the courtroom fog. And Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baca loves her gram, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind and vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvy Hill, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and shadows, yeah, this love is something rare. A Courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. Sweet Pea and the mods in the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.